Pastor Mitchell Bias, guest of the gentleman of the 20th, Doggett Brown.
Let's bow together for prayer. Our Father, we approach your throne today in the name of your Son, and we ask you to look down upon us. We acknowledge you as the creator of all things and the maker of man in your image and likeness. You have made us a little lower than the angels and crowned us with glory and honor. Psalm 115 says, "The heaven, even the heavens, are the Lord's, but the earth has he given to the children of men." Your word declares that you have predetermined our times and the boundaries of our habitation. We are occupants of this wonderful and beautiful mountain state by your divine plan. You are orchestrating history in these mountains. You have charted the course for all generations and placed us in this very important hour. We're a chosen generation, a royal priesthood, and a holy nation, your own special people. We have come today to fulfill your purposes. We ask you to bless these chambers today, our Father. Grant wisdom and favor for our West Virginia House of Delegates. Direct their deliberations today. May great grace rest upon them and their families. Protect them and keep them in the center of your will. And for all these things today, we ask in the name of your Son. Amen.
Amen. All members and guests will remain standing as we are led in the Pledge of Allegiance this morning by the gentleman of the 20th, Doggett Brown.
Thank you, Mr. Speaker. Colleagues and guests, please join me in pledging allegiance to the flag of the greatest country in the world. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Members and guests may be seated. Reading of the Journal.
Journal of the House of Delegates, Charleston, Monday, February 25th, 2019.
The gentleman of the 18th, Doggett Worrell.
Thank you, Mr. Speaker. I ask unanimous consent that the further reading of the journal be dispensed with and that it be approved as having been read.
The gentleman of the 18th asks unanimous consent that further reading of the journal be dispensed with and it be approved as having been read. Are there objections? Chair hears no objections. Introduction to guests. The gentleman of the 9th, Doggett Holland.
Thank you, Mr. Speaker. Today, our doctor of the day comes to us from Pineville, West Virginia. Please welcome Dr. Joanna Bailey.
The gentleman of the 21st, Doggett Dean.
Thank you, Mr. Speaker. In the rear gallery, we're honored to have guests from the First Two Alliance. First Two is a statewide partnership between K-12, higher ed, rural ed, to support and retain more first-generation students in STEM in West Virginia. They celebrate a $7.5 million 5-year award for the National Science Foundation. With us today are project partners Sue Ann Heatherly from the Green Bank Observatory, Erica Harvey, Fairmont State, Sarah Riley, High Rocks, Joanna Burke Kinderman, Pocahontas County Schools, and Caitlin Halley, rural education expert from ICF. Key student leaders are also here with us who will all be the first in their family to graduate college. From Fairmont State, Rebecca Rutherford, Sarah Starkovic, Marshall, Jessica Johnson, Lauren Vanskoy, and from WVU, Hannah Petronik and Abby Sign. Friends, please make them feel welcome.
The gentleman of the 47th, Doggett Phillips.
Thank you, Mr. Speaker. I'm proud to announce in the North Gallery my stepdaughter, Carrie Ferguson. She's a graduate student in education psychology at WVU, and she's here at the Capitol today in her capacity as a graduate teaching assistant for the Office of Undergraduate Research at WVU, along with some of her students who have research presentations on display in the Capitol. Please give her a warm house welcome.
The gentleman of the 43rd, Doggett Hartman.
Thank you, Mr. Speaker. On behalf of Delegate Thompson and me and the West Gallery, we have some young people from Marlinton Middle School. We have Haley Spencer, Jacqueline Teeter, Sydney Puffenbarger, Piper Colin, and Braden Hayhurst. And their chaperones, if they would all stand, and the House giving them a welcome.
Are there further introductions? The gentleman of the 22nd, Doug Jeffries.
Thank you, Mr. Speaker. I see up in the West Gallery we have several members of the West Virginia Citizens Defense League. If they'd all rise and the House make them feel welcome.
Gentleman, the 51st, Doug Hanson.
Thank you, Mr. Speaker. In the South Gallery, we have people down here from West Virginia University that I'd like to welcome. So let's please make them welcome.
Are there further introductions? If not, reports to standing committees.
Committee on Technology and Infrastructure has had under consideration Senate Bill 10 relating to Second Chance Driver's License Program, Senate Bill 153 providing greater flexibility for making infrastructure project grants, Senate Bill 542 relating to registration fees for military-related special registration plates. Reports the same back with recommendation that they each do pass, that they be referred to Committee on Finance.
Report to be received. Bills be referred to the Committee on Finance.
Committee on Technology and Infrastructure has had under consideration Senate Bill 190, DOH rule relating to employment procedures. Reports the same back with recommendation that it do pass, that it be referred to Committee on Judiciary.
Report to be received. Bill be referred to the Committee on Judiciary.
Committee on Technology and Infrastructure has had under consideration Committee substitute for Senate Bill 3, establishing West Virginia Small Wireless Facilities Deployment Act. Reports the same back with amendment with recommendation that it do pass as amended, that it be referred to Committee on Judiciary.
Report to be received. Bill be referred to the Committee on Judiciary.
Committee on Technology and Infrastructure has had under consideration House Concurrent Resolution 14, United States Army Captain Benjamin Ronk Memorial Bridge, House Concurrent Resolution 20, Private First Class Charles Everett Hurd Memorial Bridge, House Concurrent Resolution 36, Spec 5, Gary Munzel Michael Shannon Memorial Bridge, House Concurrent Resolution 47, United States Army Private First Class Arnold Miller Memorial Bridge, House Concurrent Resolution 54, United States Navy Airman Ordnance, Airman Navy, David Wayne Cornell Memorial Bridge, House Concurrent Resolution 62, United States Marine Corps Lance Corporal Michael Lynn Cooper Memorial Bridge, House Concurrent Resolution 63, United States Army Staff Sergeant Boggs G. Collins Memorial Road, House Concurrent Resolution 65, Vietnam Veterans Memorial Highway, House Concurrent Resolution 66, United States Army Specialist Thurman Dwayne Young Memorial Bridge, House Concurrent Resolution 68, Bluefield Police Lieutenant Aaron L. Crook Memorial Road, House Concurrent Resolution 73, United States Army Sergeant Matthew T. Miller Memorial Bridge, House Concurrent Resolution 74, United States Army Private First Class James Leslie Pridemore Memorial Road, Senate Concurrent Resolution 12, United States Army Corporal Lee Roy Young Memorial Bridge. Reports the same back with recommendation that they each be adopted, that they be referred to the Committee on Rules.
Report to be received. Resolutions be referred to the Committee on Rules.
Committee on Technology and Infrastructure has had under consideration House Concurrent Resolution 6, United States Army Private First Class Earl Russell Cobb, Specialist 4, Carl Bradford Goodson, and Staff Sergeant George T. Saunders Jr. Memorial Bridge, House Concurrent Resolution 9, Kingmont Veterans Bridge, Private Jarrett Springer, United States Army World War II Private First Class Benjamin Benny Hamrick, United States Marine Corps Vietnam. House Concurrent Resolution 17, United States Marine Corps Corporal Larry Scott Kennedy Memorial Bridge, House Concurrent Resolution 37, Staff Sergeant Thomas Gavin Hess Memorial Bridge, House Concurrent Resolution 40, United States Army Captain William H. Daney Jr. Memorial Bridge, House Concurrent Resolution 42, United States Navy Petty Officer Second Class Joseph Allen Ashley Memorial Bridge, House Concurrent Resolution 58, United States Army Sergeant Tommy Meadows Memorial Road, House Concurrent Resolution 64, United States Army Corporal Jerry Lee Noble Memorial Bridge, House Concurrent Resolution 72, United States Army Private First Class Harold Paul Caudill Memorial Highway, and House Concurrent Resolution 78, United States Air Force Airman Kenneth Wayne Hammer Memorial Bridge. Reports back committee substitutes, therefore, with recommendation that the committee substitutes each be adopted, that they be referred to Committee on Rules.
Report to be received. Resolutions be referred to the Committee on Rules. Are there further reports to standing committees? If not, reports to select committees. Message from the executive.
Mr. Speaker, Mr. Hanshaw presents a communication from His Excellency the Governor advising that on February 25, 2019, he approved Committee Substitute for Senate Bill 18, Committee Substitute for Senate Bill 323, Committee Substitute for House Bill 2191, and Committee Substitute for House Bill 2446.
Message will be received. Message from the Senate.
The Clerk of the Senate announces the Senate has passed without amendment House Bill 2036, permitting vehicles displaying disabled veteran special registration plates to park in places where persons with mobility impairments may park.
Message will be received.
The Senate has passed without amendment Committee Substitute for House Bill 2821, updating provisions for command, clerical, and other pay.
Message will be received.
The Senate has passed Committee Substitute for Senate Bill 238, increasing certain penalties for passing stopped school bus.
Message will be received. Bill will be referred to the Committee on Judiciary.
The Senate has passed Committee Substitute for Senate Bill 316, preserving previously approved state municipal policemen's or firemen's pensions.
Message will be received. Bill will be referred to the Committee on Pensions and Retirement, then the Committee on Finance.
The Senate has passed Committee Substitute for Senate Bill 400, allowing Board of Dentistry create specialty licenses.
Message will be received. Bill will be referred to the Committee on Government Organization.
The Senate has passed Senate Bill 421, relating to annual legislative review of economic development tax credit.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Senate Bill 432, enacting recognition of emergency medical services personnel licensure interstate compact.
Message will be received. Bill will be referred to the Committee on Government Organization.
The Senate has passed Committee Substitute for Senate Bill 441, relating to higher education campus police officers.
Message will be received. Bill will be referred to the Committee on Education.
The Senate has passed Committee Substitute for Senate Bill 511, creating alternating wine proprietorships.
Message will be received. Bill will be referred to the Committee on Government Organization.
The Senate has passed Senate Bill 535, allowing City of Buchanan to begin collecting sales and service and use tax on July 1, 2019.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Committee Substitute for Senate Bill 538, relating to West Virginia Highway Design Build Pilot Program.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Committee Substitute for Senate Bill 539, relating to accrued benefit of retirees in West Virginia State Police Retirement System Plan B.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Senate Bill 544, increasing salaries for members of West Virginia State Police over a 3-year period.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Committee Substitute for Senate Bill 547, limiting landowner liability for recreational use of lands.
Message will be received. Bill will be referred to the Committee on Judiciary.
The Senate has passed Senate Bill 554, removing salary caps for Director of State Rail Authority.
Message will be received. Bill will be referred to the Committee on
The
Finance.
Senate has passed Senate Bill 592, providing for a collection of hotel occupancy tax by marketplace facilitators.
Message will be received. Bill will be referred to the Committee on Government Organization, then the Committee on Finance.
The Senate has passed Senate Bill 596, adjusting voluntary contribution amounts on certain DMV forms.
Message will be received. Bill will be referred to the Committee on
The
Finance.
Senate has passed Committee Substitute for Senate Bill 597, conforming state law to federal law for registration of appraisal management companies.
Message will be received. Bill will be referred to the Committee on Government Organization.
The Senate has passed Committee Substitute for Senate Bill 603, exempting certain activities from licensing requirements for engaging in business of currency exchange.
Message will be received. Bill will be referred to the Committee on Judiciary.
The Senate has passed Senate Bill 627, relating generally to rural rehabilitation loan program.
Message will be received. Bill will be referred to the Committee on
The
Finance.
Senate has passed Committee Substitute for Senate Bill 654, amending definition of mortgage loan originator.
Message will be received. Bill will be referred to the Committee on Judiciary.
The Senate has passed Senate Bill 656, relating to electronic filing of tax returns.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Senate Bill 665, allowing for expedited oil and gas well permitting.
Message will be received. Bill will be referred to the Committee on Energy.
The Senate has passed Senate Bill 666, creating West Virginia Motorsports Entertainment Complex Investment Act.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Senate Bill 667, creating West Virginia Motorsports Committee.
Message will be received. Bill will be referred to the Committee on Government Organization. Are there further messages from the Senate? Resolutions.
House Resolution 16, recognizing the recent rise in black lung, particularly progressive massive fibrosis, the most deadly form of black lung in West Virginia.
Lady from the 49th.
Mr. Speaker, I ask unanimous consent that further reading of resolutions introduced be dispensed with and they be considered as formally introduced and referred to the appropriate committees as indicated on the chamber automation system.
The lady from the 49th asks unanimous consent that further reading of resolutions introduced be dispensed with and that each resolution be considered as having been formally introduced and referred to the appropriate committees as shown on the chamber automation system. Are there objections? Chair hears no objections. Petitions, motions, bills introduced, unfinished business, bills on third reading.
Committee substitute for House Bill 2011, Road Maintenance Program.
The gentleman with 56, Dougett Howell, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to create a road maintenance program allowing private companies to perform road maintenance in each state highway district by permitting the Division of Highways to contract with a private contractor. The contracts will be based on competitive bids in the manner that DOH sees appropriate and requires the district to obtain its services and materials from the lowest responsible bidder. I urge passage.
The question before the House is, shall the bill pass? The lady from the 50th, Dougett Longstreth.
Thank you, Mr. Speaker. Would the chairman yield for a question?
Chairman does yield.
On this, I have a question on this only because you're trying to bid the contract out. Why can't we, are we saving money, or why can't we not hire some more people under DOH?
Well, I know DOH has had some hiring problems, but what this does is if there is money left over in their maintenance budget that is unspent, that money can then be used with private contractors to fill in that gap.
And that's the only reason, because we don't have enough people to hire, that we'd have to contract it out?
That's not necessarily true. There could be other reasons. You know, we've had an extremely wet last year, which meant a lot of days they couldn't work, and you just, you know, by having more crews, you can do that.
But these are private contractors. They could be from anywhere. Is that true?
It would go to the lowest responsible bidder. Most of them would be in state.
Thank you.
The lady wish to proceed?
No, I have no other questions. Thank you.
The gentleman, the 36, Dougett Robinson.
Here will the chairman continue to yield? Chairman, how many districts, what date do we determine there's an excess in their fund?
End of the fiscal year.
End of the fiscal year? How many districts this year had a surplus in their budget at the end of the fiscal year, last year?
Typically, there's some left over. It varies from year to year and from district to district. They also shift money around within the system sometimes.
So how many districts last year would have had money left over for this program?
I don't have a specific number on which districts had money left over.
We don't know?
Testimony from DOH, they did not give us that number.
So at the end of the fiscal year, we decide if there's leftover money, we're going to contract it out. Have we talked to district supervisors and asked them if contracting out's the best method or hiring more people? I mean, did you talk to any district supervisors about that?
Two things. One, I've talked to the district supervisor in my district.
Go ahead. What do you have to say about that? I'm sorry to interrupt you, but what do you have to say?
One of the things that they had said was equipment shortage, and also the weather was a big factor in them not being able to complete stuff.
Did your district have excess last fiscal year?
Two of my counties managed to spend all their money. The rest did not.
Your counties or districts, highway, DOH districts?
Well, each highway district is made up of a number of counties. I'm in District 5, which is Hardy, Grant, Mineral, Hampshire, Morgan.
Did that
Berkeley,
district
and
have an
Jefferson.
excess?
Only Hampshire and Mineral, which is my home county, were able to spend all of their money.
But I think if we look at the bill, we're talking about districts, not the county, correct? So we're talking about District 5.
The districts are made up of counties, and each county has a maintenance budget from within the district.
Okay, so the entire District 5 is what we talk about in here. If they have an excess, they can contract out, correct?
That would be the way the bill
So
works, yes.
Did District 5 have an excess?
Yes, because only 2 counties actually met their goal.
Okay, and what was that excess?
I don't have that number.
Okay. Now, if we go to this, are we looking at, I mean, are we going to see a point where we allow them to hire private contractors? Are we going to see layoffs at DOH or a decrease in the labor force there? I mean, we're going to have other private contractors doing out some of the work that they complete. Are we going to be able to decrease who we hire at DOH?
This is only used for excess budget money.
Okay. But we don't know what districts had an excess, correct?
There would be a number. It was not presented to the committee by DOH.
Do you think we should look into that possibly and figure out what districts would have that, or we just pass this and hope it works out?
Well, 2011 looks into that's the purpose of this bill.
Oh, okay. Thank you.
The gentleman of 35th, Doug Byrd.
Thank you, Mr. Speaker. Will the chairman yield for just one question? I'm just trying to understand the timeline here. So you said it ends fiscal year, you'll know your excess, correct?
Correct.
When is it that they're put out for bids? What time period do they have to put out the bids by?
It'd be the following fiscal year.
Like, I mean, is there a set date, though, that they have to submit out to vendors to say, I think you're getting an answer.
December 1st, which will be 5 months into the new fiscal year, and the bids are to be put out by February 1st.
Okay, that's my confusion. Wait, December or February?
December is when they decide what if they want to spend the excess, and they put the request the bids, I should say.
Okay, and the reason why I was asking, my confusion was on line 6, it's talking about the contract is going to be in February for vendors. And so are you saying that we learn our excess in July, you submit the bids in December or February? That's the only thing I'm trying to figure out is the timeline in the bill. And that's my only question. So I think it might be backwards.
December 1st is when they begin the review of the unfinished products or projects. And then February 1st is when they have the bids in from the contractors to complete those.
Okay, thank you.
The gentleman of 16th, Doug Linville.
Thank you, Mr. Speaker. With Chair, continue to yield. There's been a lot of discussion here in regards to how much money that these folks may or may not have at the end of the year. I know you serve on technology and infrastructure with me. During questioning, do you recall that the department could not give us any sort of an idea as to the total amount of monies that they had spent and the percent to completion that they were at on each of these different districts for their core maintenance plan?
Yeah, so I remember that.
And was it discussed there that part of the usefulness of this bill is that they would have to produce that report to an interim committee every year so that we could evaluate what the causes for them not completing this work are?
Yes.
Okay. Thank you, sir. If I can speak to the bill.
Gentleman, proceed.
Folks, we're getting caught up on two things here. First is, do our roads need more money? Absolutely. I think every single one of your constituents agrees with that. Mine do too. But part of the effectiveness of this bill is that we're going to be able to measure and analyze exactly how these folks are spending our money and exactly why there's a holdup. In some cases, it may be staffing. In some cases, it may be not enough money. In some cases, it may be mismanagement. But this will tell us exactly all of that every single year. This allows for folks to contract work out only in instances where they were unable for whatever reason and have the money available to do so. If they do not have the money available to do so, there is no mandate that they contract anything out because they don't have the money. We're getting caught in the weeds here on this bill. I urge adoption. It is a great bill and the result of an immense amount of work between a huge number of us to try to fix one of the biggest complaints that mine and every one of your constituents has, and that's that our roads look like Swiss cheese. Pass this bill.
The gentleman of second, Doug Desario.
Thank you, Mr. Speaker. Will the chairman yield? Mr. Chairman, I want to make sure I'm on the right bill here. Is this the bill that says that there's 70% of the money that goes into the core maintenance and 30% goes into what they would call highway maintenance?
This bill references their maintenance program, but what you're talking about is internal policies of DOH.
So, but I am on the correct bill, right? So this is saying that you have to spend 90% of the core maintenance money. Is that correct?
That's not correct. It meant 90% of the maintenance budget, which includes core and non-core maintenance, is if they do not reach that 90% level, that remainder can be contracted out.
Was it not explained to us in committee the other day by the Department of Highways that there is 70% in a fund that does core maintenance, such as ditching, and then there is 30% over here? And that money in the core maintenance gets moved around because they need the money for slips and other maintenance that falls in that 30% range. Doesn't some of that money get moved over here, which does not enable you to spend all that money? Was that not presented to us?
You're confusing two issues here. Core maintenance and non-core maintenance is part of the entire budget.
Yes, sir.
DOH's internal goal is to spend 70% of that money on core maintenance, the remaining 30% on non-core. Sometimes because of slips, they spend what would be normally core maintenance on non-core. What this bill does is if 90% of that total budget is not spent in a fiscal year, then they can contract that out to complete work.
Okay, I don't see where I'm confusing it, because the way it was explained to us in committee is that money is almost always spent 100%. That's the way it was explained to us by the Department of Highways, that money, there's hardly ever any money left over. But what he said was just what you just now said. I don't see where the confusion is. They have to prioritize stuff. So if they have 70% in that core maintenance, and they have a slip over here that closes the road down, they have to take some of that money from core maintenance and fix that slip. Is that not what he told us?
That's all within their maintenance budget.
So
Their
does
goal is
that prohibit them
74.
from spending all the money on core maintenance?
This bill does not address core maintenance specifically in the spending. It says if 90% of their total maintenance budget is not spent, then the remainder can be spent with contractors.
So I was in the right meeting, right? I mean, when this guy talked, when the fellow from the Department of Highways talked the other day, did he not tell us that very rarely is there money left over?
If there's no money left over, then this will, part of the code will not be used.
Okay, but that's what he told us, and he also told us that is why we don't always spend the money in the core maintenance program. Correct? He did tell us that.
This bill references the total maintenance budget, which includes core and non-core maintenance.
All right, thank you, Mr. Speaker.
Does the gentleman with 56, Douglas Howell, wish to close debate? Question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 83 ayes, 15 nays, 2 members absent not voting. A majority of those present having voted in the affirmative. Chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2011.
Are there amendments to the title? If not, the title as read by the clerk will be in the title of the bill. Lady from the 49th.
Mr. Speaker, I move that the bill take effect July 1st, 2019.
Lady from the 49th moves that the bill be made effective July 1st, 2019. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 95 ayes, 3 nays, 2 members absent not voting, 2/3 of those elected having voted in the affirmative. The chair declares the bill effective July 1st, 2019. Clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2014, West Virginia Intellectual Property and Trade Secrets Act.
The gentleman 27th, Douglas Schott, to explain the bill.
Thank you, Mr. Speaker. This bill will definitely test whether we're awake this morning. It deals with trade secrets and intellectual property, something I'm sure with which you're all very familiar. Basically, the thrust of this bill is to attempt to make West Virginia the leading state in the nation in terms of protection of trade secrets and intellectual property. It basically does that by modifying our Uniform Act, not reducing any of the protections that are currently in it, but increasing protections for trade secrets and intellectual property. Traditionally, intellectual property rights have been protected at various levels. The federal law protects patents and copyrights, while state law typically covers trade secrets. And trade secrets include generally information including but not limited to a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value and is subject to reasonable efforts to maintain secrecy. The bill before you looks to expand upon the realm of protected intellectual property by protecting additional secret information that has commercial value but may not be covered by existing trade secrets law. To that end, the bill builds upon the protections already contained within the state's existing Trade Secrets Act. And as I mentioned before, no protections that currently exist in the Act have been removed. The bill attempts to build upon those trade secrets law by adding a formula definition for intellectual property. That definition is taken from the Agreement on Trade-Related Aspects of Intellectual Property Rights. The acronym is TRIPS, T-R-I-P-S. The TRIPS agreement is an international legal agreement recognized by all member nations of the World Trade Organization. In addition to existing trade secret protections, the bill protects any additional intellectual property from improper disclosure or use. It also provides protections for any breach of a non-disclosure or employment agreement by an employee for purposes of misappropriation of intellectual property or trade secrets. The bill also seeks to provide enhanced penalties for the unauthorized use of intellectual property or trade secrets and provides criminal, civil, and injunctive relief for any unlawful misuse of intellectual property or trade secrets. The bill specifically changes the Uniform Trade Secrets Act for the express purpose of providing greater protections for intellectual property and trade secrets in West Virginia, with hopes of setting the state apart as an attractive place for entrepreneurs to locate. However, it is important to note that the bill does not alter in any way the protections provided for in the state's existing Trade Secrets Act. To the contrary, the bulk of the bill is the state's existing Trade Secrets Act. While this article is a uniform act, the act can be modified to add additional levels of protection to intellectual property without negatively impacting the goal and premise of the Uniform Act. The force and continuity of the Uniform Act will not be impacted by this bill, which merely has been expanded to provide even greater protections for intellectual property than that's contained in the current Uniform Act, while providing for enhanced penalties and civil protections for any violations of the Act. Consequently, the bill is an opportunity for West Virginia to take the lead on intellectual property protections and provide enhanced protections that will encourage entrepreneurs to locate within the state. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? The gentleman of the 60th, Doug Wilson.
Thank you, Mr. Speaker. May I address the bill?
Gentleman may proceed.
Thank you, sir. If we hope to build wealth in this state, we must recognize private property, the right of private property. That is the foundation of wealth building in any society, in any place, anywhere in the world. That's a principle. Now, I found this bill to be pretty complex, technical. I'm not a communications guy. I'm not a computer guy. So some of the technical aspects were rough on me, but the principles were very simple. This is private property. Because you own yourself, you own the work of your hands, you own the work of your mind, you own what you produce. And if you own what you produce, you have a right to protect it. It's that simple. Please pass the bill. Thank you.
Does the gentleman 27th wish to close debate? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 1 nay, 1 member absent, not voting. A majority of those present having voted in the affirmative, and chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2014.
Are there members of the title? If not, title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2049 relating to prime contractors' responsibility for wages and benefits.
For what purpose does the gentleman 27th, Delegate Schott, seek recognition?
Mr. Speaker, if we're on 2049, I ask unanimous consent to amend the bill on third reading to correct a technical error.
The gentleman 27th asks unanimous consent to offer an amendment to the bill on third reading. Are there objections? Chair hears no objections. Gentleman may proceed.
Thank you, Mr. Speaker. This is purely a technical amendment. The word "and" was misplaced. There's a list of factors. The word "and" should have been before the next to last one instead of the last one. We're simply moving the "and" to where it should be and putting a semicolon there and a period at the end of the last section. Urge adoption.
The question before the House is the adoption of the amendment as just explained by the gentleman 27th. Those in favor will say aye. Those opposed will say no. Ayes have it. Chair declares the amendment adopted. Are there further amendments? If not, clerk will read the bill a third time.
Committee substitute for House Bill 2049 relating to prime contractors' responsibility for wages and benefits.
The gentleman 27th, Douglas Schott, to explain the bill.
Thank you, Mr. Speaker. This bill seeks to impose some balance on a situation that's currently provides no protection. It deals with a prime contractor's obligation to the employees of a subcontractor whose wages or benefits are not paid. Currently, a employee of a subcontractor has a claim against the prime contractor for those wages and benefits without any limitation or requirements other than that the employee pursue all remedies against his employer, the subcontractor. This bill alters that some way in an effort to try to provide some ability for the prime contractor to protect itself, at the same time not depriving the employee of its rights if it moves within reason, within a reasonable period of time. Here's how it works. The bill currently amends the current law and says that an employee can pursue a cause of action against the prime, but first it must notify the prime contractor of within 100 days of when the wages or fringe benefits became payable. Second, it must file suit within 1 year of the notice. And third, it must provide proof, such as a pay stub or a time card or something like that, to substantiate the claims. If the claim is successful, the prime contractor is liable for the wages and benefits due, but not liquidated damages, but is attorney's fees and interest. Now, the purpose of the bill, though, is to allow the prime contractor to protect itself by withholding in the form of retainage or some other fashion from the subcontractor for that 100-day period to protect itself from the claim of any employee. We have removed the requirement that the employee pursue its full remedies against the subcontractor because of the time frame involved in that. In other words, it could be up to 2 or 3 years before that claim is resolved. In the meantime, the prime contractor has not had any opportunity to protect itself by withholding for that period of time. So basically, it does not remove, it does remove the obligation on the employee to pursue those claims against the subcontractor, but it must notify the prime contractor within 100 days of when they determine, when those wages become payable. If the prime contractor has to pay under the bill, then it has the right to pursue that claim against the subcontractor. That's current law, and that has not changed. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? The gentleman from the 3rd, Douglas Fluharty.
Thank you, Mr. Speaker. Gentleman yield.
Yes.
Okay, just so we're clear on this, the person seeking redress here, that's the employee, right?
That is correct.
And the work has already been done. So this is for services rendered.
Correct.
So we're making it harder for an employee compared to current law to get paid, basically.
I wouldn't say we're making it harder. We're asking the employee to notify the prime contractor so the prime contractor has the ability to protect itself and then pay those wages within that time frame.
Okay, say we had a prime contractor, for instance, at the Greenbrier, and payment was not made from the prime contractor to the subcontractor, okay? Subcontractor was then unable to pay the employee. Or any scenario under that, the subcontractor was unable to pay the direct employee. Employee then seeks redress. If they fail to get it from the subcontractor, they then go after the prime contractor, correct? That's currently how it has to happen.
let me make sure I understand your example. The prime doesn't pay the sub doesn't pay the employee.
We'll start from the beginning.
Okay.
The sub doesn't pay the employee.
Okay,
Employee goes after the sub for their money for the work they've done. They don't get their money. They then go after the prime. But under current law, they have to go after the sub first. They have to exhaust that remedy.
they have to exhaust their remedies, which could be a lawsuit that could extend for
Okay.
years.
So that's under current law.
That's current law.
Okay, and now we're going from, was it a 5-year term? How under current law?
Under a contract, if it's written, it's a 10-year statute of limitations. If it's an oral contract, it's a 5-year limitations.
So now we're drawing that back to a notice requirement of 100 days to the prime.
We have, yes, for the prime contract, for this remedy, of course, we've removed any obstacle to filing a mechanics lien. So obviously, the employee still has the ability to file a mechanics lien against the improvement. The employee also has the right to seek recovery of the wage bond if there's one posted. If it's a new employer, there would be a wage bond to back that up as well. But in this case, we've removed the requirement that the employee have to pursue the subcontractor because of the length of time that could be involved in that. So the idea is to try to get them paid sooner rather than later.
Okay, so I'm clear, the notice requirement's 100 days?
Within 100 days.
Within 100 days,
Yes.
and then the suit must be filed within a year.
The suit has to be filed within a year.
Okay, and currently, that's not the case. It's longer.
The suit could be 5
5.
years later.
Okay.
If the employee wants to wait that long.
All right, thank you. Very briefly.
Gentleman, proceed.
While I'm happy that we made this bill better, it's still, I believe, a bad bill because we're talking about work that has been rendered. You know, the guy on the lowest of the totem pole that's done the work doesn't have the ability to go hire attorneys. It was not paid for his day's work, which I think is a premise we should all abide by. You get paid for your day's work, and we're making it harder for them to get redress and get paid for the work they've done. So I'll be voting no on the bill. Thank you.
Are there other members who wish to speak to the passage of the bill? The gentleman to 36, Doggett Rowe.
I just had a question of the chairman, if he would yield.
Chairman does yield.
Certainly.
Now, does the employee have to file a lawsuit to invoke the protections of this statute?
Under current law, the employee would have to file a lawsuit. Under this law, assuming the prime contractor did not pay, the same situation, they'd have to file a lawsuit either way.
Okay, so current law is that the lawsuit has to be filed, but it doesn't have the 100-day period.
Current law does not require that a lawsuit be filed, but it simply makes the employer, the prime contractor, liable. But obviously, the situation, if the prime contractor refuses to pay, there would have to be a lawsuit, just like there would be under the current law, except they would have to be filed sooner, hopefully resolving the claim sooner than later.
Okay, I'm not quite understanding. One more time. Under this provision, the employee has to file a lawsuit in order to invoke liability by the prime contractor?
Under this provision, they would first have to notify the prime contractor within 100 days. If that doesn't result in a resolution of the claim, then the employee would have up to a year to file the lawsuit for attorney's fees, costs, and recovery of the wages.
Whereas now, there's no 100-day requirement.
That's correct.
And the prime contractor is liable, but in order to enforce that, the employee would have to go ahead and sue the prime contractor if they refuse to comply.
The employee would have to do two things under the current law. The employee would first have to exhaust all of its remedies against the subcontractor, which by implication could mean a lawsuit against the subcontractor. Once that was resolved, if the prime contractor failed to pay, then the employee would have to file a second lawsuit against the prime contractor.
All right, thank you, sir. Thank you, Mr. Speaker.
The gentleman to 48, Doggett Miley.
Thank you, Mr. Speaker. Would the chairman continue to yield?
Yes.
I know we're just dealing with one section of Chapter 21, but how would an employee, a general laborer, even know who the prime contractor is? Is there some place where documents are filed that a general laborer could go and identify who the prime contractor is to provide such notice?
I guess it depends on the type of structure we're talking about. Obviously, on a home, if you were building your home, most likely they would have contact with the general contractor who's building the home and be aware of that. In bigger commercial projects, oftentimes it's there's a big poster board out front as to who's in charge of it and so forth. It would be the same problem under the current law if they don't know who the prime contractor is. They wouldn't know who to ask to pay these wages, just like it would be under the proposed change in the law.
And I understand that. My only concern is, under the current law, they have a little longer than 100 days to find out, and they might have to find out by the assistance of an attorney or somebody else. But now, with such a limited period of time, I'm just concerned that a general laborer may not have any idea where to go look to find the proper name, the proper address to send the certified mail piece to the prime contractor. And I didn't know if somewhere else in this chapter there are requirements that the prime contractor have to file something somewhere that would put someone on notice. Do you know?
I'm not sure. I'm not sure of that fact. And there's a lot of notification requirements spread throughout the code. I'm just not sure I can answer that question.
Okay, thank you.
Sure.
The gentleman, the 53rd, Doug Jennings.
Would the gentleman yield, please?
Yes.
If I was a subcontractor employee and my boss didn't pay me, and I could show on my check stub and say he cheated me out of so many hours, and I go back to my my boss and he said, well, I'm not going to pay you, then I can run right up to the main contractor and say, you can see right here my hours I put in and my boss didn't pay me. The main contractor will say, okay, I'll take care of that. I'm going to pay you right now. Now my grief, I withheld the money from the subcontractor, so that money, I'm going to deduct that amount. Isn't that what we're doing here?
Yes, we're trying to provide some balance to the situation and provide a mechanism by which the prime contractor can protect itself. If it's a responsible prime contractor, it can withhold 5 or 10% of the contract price from the subcontractor to cover those type situations.
Well, wouldn't this help the employee in a way because he could get resolved much quicker, much easier without going to a lawyer?
It certainly could. It certainly could, because under the current law, the employee could ultimately have to file 2 lawsuits to get their money over a much extended period of time. In this situation, hopefully by notifying the prime contractor within the 100 days, it would be resolved before the prime contractor released the final payment to the subcontractor.
Thank you. Thank you, Mr. Speaker.
The gentleman, the 15th, Doug Foster.
Thank you, Mr. Speaker. I'm going to speak in favor of the bill. What this bill does is, and it's kind of been a long explanation here, but right now, current law in this section allows basically somebody to not pay their bill. For example, a subcontractor, somebody doesn't pay their bill, and it forces the prime contractor, for whom has no obligation but is forced to pay the unpaid debts of another. Well, what this bill does is basically say, well, they have to be notified, whereas the prime contractor can hold out retainage. And if you don't know what that is, basically they hold out retainage in a contract. And this is done for many settlements of making sure the job's completed appropriately. Well, they could hold out retainage and basically force the bad actor to suffer not having to pay. Basically suffer and have to pay. Right now, a subcontractor can just not pay their bill and the prime be stuck with it. So what this is doing is allowing the prime to hold out retainage and make the money come out of the pocket of the person who is actually the bad actor. So I would urge passage.
Does the gentleman, the 27th, wish to close debate?
Thank you, Mr. Speaker. Let me just summarize what current law is and how this changes current law. Current law and it protects an employee in several different ways. If he's an employee of a subcontractor, he has the right to go against the prime if he's not paid. But first, he has to pursue all remedies against the subcontractor. He also has the right to file a mechanics lien against the improvement that the contract resulted in the construction of. And we also have a wage payment bond requirement for new businesses that have been in business less than a year that would also be a source of recovery. What the bill does is try to bring a little more balance to that situation and hopefully result in a quicker resolution of the claim. We've removed the requirement that the employee have to pursue and exhaust all remedies against the sub, and instead basically said if you'll notify the prime within 100 days, then the prime is responsible, and if they don't pay, then within a year you can file a lawsuit and force that. You still have the right to seek recovery under the wage bond if there is one. You still have the right to file a mechanics lien. Neither of those things have been changed. If you have to file a suit under this provision against the prime contractor, you're entitled to recover your attorney's fees and interest. I think it's an improvement on the situation. It gives some more balance, but more importantly, it provides a way by which the prime contractor can hold money back from the subcontractor and assure that it comes out of the pocket of the person most responsible and the employee still gets paid. I urge passage of the bill.
The question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 58 ayes, 41 nays, one member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2049.
Are there amendments to the title?
Delegate Schott moves to amend the title.
The question before the House is the adoption of the title amendment. Those in favor will say aye. Those opposed will say no. Ayes have it. Chair declares the title amendment adopted. Title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2378, relating generally to grounds for revocation of a teaching certificate.
The gentleman from the 48th, Delegate Hamrick, to explain the bill.
Thank you, Mr. Speaker. 18A36 of the West Virginia Code sets forth grounds for revocation of teaching licenses and describes the process therefore. The code section currently allows for automatic revocation of the license of someone who is convicted of sexual abuse by a person of trust. This bill would expand the automatic revocation to include teachers who have been convicted of any criminal offense that requires the teacher to register as a sex offender, or any criminal offense in which distribution or delivery of a controlled substance is an element. The bill also adds an automatic termination clause for child abuse and extended state statutory references regarding child abuse and sexual abuse to include comparable convictions in other states. Mr. Speaker, I urge passage.
The question before the House is shall the bill pass? Or the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. In this question, there are 99 ayes, 0 nays, one member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2378.
Are there amendments to the title? If not, title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2396, West Virginia Fresh Food Act.
The gentleman, the 63rd, Douglas Hardy, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to require that state-funded institutes such as schools, colleges, correctional facilities, state agencies, state parks to purchase a minimum of 5% of its fresh produce, meats, poultry products from an in-state producer, provided the produce meats and poultries are available from an in-state producer. The purpose is to encourage and stimulate economic activity in the West Virginia farmers and to support availability of fresh local foods. I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. In this question, there are 98 ayes, 1 nay, one member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2396.
Are there amendments to the title? If not, the title was read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2397, requiring county school boards to provide adequate mental health and counseling services.
Lady of the 49th.
Thank you, Mr. Speaker. I ask unanimous consent to postpone action one day.
Lady from the 49th asks unanimous consent to postpone action one day on committee substitute for House Bill 2397. Is there objection? Chair hears no objection. Action will be postponed one day. Next bill on third reading.
House Bill 2497 relating to whistleblower law.
The gentleman, the 35th, Dr. Capito, to explain the bill.
Thank you, Mr. Speaker, and good morning, ladies and gentlemen. This bill applies to whistleblowers that are within the gamut of the civil service system here in West Virginia. And essentially, I think we're all familiar with what a whistleblower is. And the bill before you actually provides more protections for whistleblowers. And essentially what we're doing is here we're codifying protections that have been handed down through the court system in West Virginia. So we're making them a part of our code. And essentially what this bill does, it says that a person that is considered or defined as a whistleblower cannot be passed up for a raise or a promotion. And if in the case that they are found to be passed up for a raise or promotion, they're able to file a retaliatory action in front of a grievance in front of the West Virginia Public Employees Grievance Board. Also, this bill actually provides that those employees that are covered under the civil service system also are not prohibited from engaging in political activity so long as that political activity does not take place while that employee is on duty or acting in an official capacity. Additionally, the employee covered by the civil service system cannot be, no employee may be denied the right to be a member of an organization of employees or may be refrained from being a member of an organization of employees. Mr. Speaker, that's the bill. I urge its passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, 1 member absent not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 2497.
Are there amendments to the title? If not, the title is read, will the clerk will read and remain the title of the bill. Clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
House Bill 2535 relating to purchasing exemptions and procedures.
The gentleman of the 28th, Doug Pack, to explain the bill.
Thank you, Mr. Speaker, and good morning. The purpose of House Bill 2535 is to clarify the handling of purchases made by the Division of Corrections and Rehabilitation. The bill provides that any claim, unless something different is indicated, incurred while carrying on the division's business, including but not limited to contracts with any other governmental agency of the state of West Virginia or of the federal government, including labor done for materials, services, commodities, or supplies furnished to the division, shall be audited by the division. That is the bill, Mr. Speaker. I urge its passage.
Question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, 1 member absent not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 2535.
Are there amendments to the title? If not, the title is read, but the clerk will read and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2617 relating to the form for making offer of optional uninsured and underinsured coverage by insurers.
The gentleman of the 27th, Douglas Schott, to explain the bill.
Thank you, Mr. Speaker. In this cyber world that we live in today, it's my understanding that a number of individuals solicit insurance over the internet. And when I'm saying the number of individuals, the potential insured. Basically what this bill does is to require the insurance commissioner to provide for the use of electronic means of delivery and electronic signing of the form for making an offer of optional uninsured and underinsured motorist coverage by insurers. It provides that any signature executed in conformity with the Uniform Electronic Transactions Act is enforceable. The second part of this bill is to require the insurer, when offering to place an insured with an affiliate of the insured, to make available a new uninsured and underinsured motorist coverage offer form. And if the insured does not return the form to the insurer within 30 days, then the last form that was previously signed by the insurer for that insurer or any affiliate shall govern the amount of uninsured and underinsured coverage provided by the newly issued policy. In other words, it transfers the coverage from the old policy to the new policy. To the members, there are a number of insurance agents among our members. I think the gentleman from the 12th, the gentleman from the 40th may be able to offer more technical assistance if there's questions, but I'll try to do whatever I can to answer those questions, recognizing that I am kind of a cyber saurus in this field. So that's the bill, Mr. Speaker. I urge its passage.
The question before the House is the passage of the bill. Are there questions for the Cybersaurus? The gentleman from the 36, Delgate Road.
Yes, sir, there are. If you would yield, sir.
Sure.
As I understand the bill, if a person were to consent by maybe just checking off a little box that they agree to electronic notices and they have not used electronic means for any of their insurance business, would they be entitled to paper notice?
My understanding of the bill, and I think, as I said, I would defer to those who actually operate this system, is that the consent form, they have to consent to electronic communication for the process. And that typically, they've initiated the inquiry through the electronic means over the web, for instance. So they basically, by doing that, they have elected the means of communication. Now, that's about the best I can do.
And well, that certainly
makes sense. It seems clear in the
sense.
bill that they have to consent to that form of communication.
Yes, sir. Well, as I understand it, what's at issue is the requirement in code that these coverages, uninsured and underinsured coverage, must be offered anytime coverage is changed for the insured. And so now what we're doing is we're seeing people apply electronically for insurance, which is a good thing. And those folks would naturally receive notices back because they're kind of savvy electronically. But my concern is the person who uses paper and walks into the offices of the agent, that those folks could unknowingly check a little box that they can take notices electronically and be given a notice that they really don't understand and it's not in the normal course of what they do. But there's no protection in this statute for that, correct?
The only response I can give you, and once again, I'd probably refer you to someone who practices in this field, but you know, the area of informed consent to underinsured and uninsured coverage has been litigated extensively, and the courts have made it clear it has to be a knowing waiver of that type of coverage or anything of that sort that affects the ability to make that election. So I think within the body of current litigation and court decisions, there's adequate protection to be sure the person makes a knowing if they waive that coverage or the coverage that is waivable. Some of it's not. Obviously, there's some minimum coverage issues, but I think there's adequate protection in the body of law that already exists. But as far as the operation of this new system of electronic communication, I think you'd be better off to, and I imagine those people would yield for questions to give you more specific information.
Thank you, sir.
Sure.
May I speak to the bill?
Gentleman, proceed.
Thank you, Mr. Speaker. The bill involves a very important insurance coverage, and that's uninsured or underinsured coverage. And usually those coverages come into play if there's a catastrophic, very serious injury. And that's why this is an important area and why the notice is in code and has remained in code for probably 30 years to require that people be specifically offered underinsured coverage. Now, uninsured comes to you through your policy by code and is required. But under coverage means that if the other person doesn't have enough coverage for your injury, then you bought coverage to come in on top of that on your own policy. It's very important coverage. I just point out to the members that as people deal electronically, that's fine. And if they receive notices back electronically, that's fine. But in this bill, there's nothing required to say that if a person is transacting with the insurance agent by paper, that the notice come to them by paper. It might come in an email and they'd be surprised by it. So I just point out that is a concern for the statute. It does try to make it clear that electronic notice is allowed, at least for persons who deal electronically with the agent. Thank you, Mr. Speaker.
The gentleman from the 29th, Douglas Steele.
Thank you, Mr. Speaker. You know, one thing that the gentleman from the 36 brought up that we actually talked about this quite a bit in the committee, and when we had opportunities to question folks from the industry as well as counsel, one of the things that stood out to me, because I had some of the same concerns, is what this bill does and what it will do in practice is, let's say you have an in-force automobile insurance policy, and let's say that your underinsured limit is $100,000. and you've signed up for these electronic notifications and so forth. So let's say you get that electronic notification that it's time for you to renew and you need to update this form. And like a lot of the emails that come through, sometimes we don't notice it, or it hits a spam folder, or for one reason or another, we don't take action when that policy comes to renew. What the bill does is it actually makes it to where if you fail to turn that in, you don't lose coverage. You default to the coverage that you already have. So one important thing I hope you'll remember is you don't stand to lose any coverage by failing to turn that form back in or failing to make that electronic notification. That's one thing that made it a little bit easier for me, because I had some of the same concerns, maybe not along the same lines, but that was one thing that definitely stood out to me, is I'd hate to see someone lose some coverage because they failed to turn one of these forms in, because we know how easy it is to forget some of these emails. But just so everybody knows, no one can lose coverage by failing to turn the form in. You just default to what you already own. So I hope that clears that up a little bit.
Does the gentleman from the 32nd, Doggett Fast?
Thank you, Mr. Speaker. I also just wanted to point out when a form like this is offered electronically, we did pass an amendment. I think it's an important amendment in judiciary, that the form cannot be pre-filled out. When you get one of these forms, it has elections. You can elect to either reject the underinsurance coverage, or you can elect to accept certain levels. And of course, the higher the level, the more the premium will cost you. But the form as to the election selections cannot be pre-filled out for you, nor can the signature line be pre-completed. I've seen situations where a form was supposedly offered and had everything filled in, and the insured, after the accident, like, what is this? Didn't even know what it was, and said never even saw it before. So that form is not to be pre-filled in, so it's going to force the insured to at least put their eyes on it and make the selections themselves and type in a signature or do an electronic signature under the Electronic Signature Act. So I think it's a good bill.
Does the gentleman at 27th wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 95 ayes, 4 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2617.
Are there amendments to the title? If not, the title was read, the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2662, relating to certificates or employment of school personnel.
The gentleman, the 48th, Doggett Hamrick, to explain the bill.
Thank you, Mr. Speaker. This is a companion bill to House Bill 2378. This bill does the same thing that 2378 did for teachers, but for bus operators and service personnel. Mr. Speaker, I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. Of this question, there are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill pass. Or the clerk will please report the title.
Committee substitute for House Bill 2662.
Are there amendments to the title? If not, the title as read, but the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 2665, supplemental appropriation for PEIA rainy day fee.
The gentleman, the 64th, Doggett Householder, to explain the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, the purpose of this supplementary appropriation bill is to add a new item of appropriation and appropriate $105 million in general revenue from the unappropriated balance of general revenue for the fiscal year ending June 30th, 2019, to the Department of Revenue to be available for expenditure during the fiscal year 2019 in the following fund, PEIA Rainy Day Fund, in the amount of $105 million. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? The gentleman of 36 Doggett Row.
Would the gentleman yield for a question?
Chairman does yield.
Could you explain to us what the rainy day fund is and if it is concurrent code?
It's a bill that's coming up here later on. It's House Bill 3139. This is where this money will be going to, into House Bill 3139, this rainy day fee that's used to help offset. There's an assessment in this House Bill 3139 that's going to be charged to the agency, and this is the money to help offset that assessment.
Okay. And the assessment, is that bill on today's agenda? I failed to look.
Yes.
Okay. And so what it would do is set up this fund. This is just putting money into the fund.
Exactly.
And if that bill were not to pass, would we have a fund to pay into?
The budget analyst says if that bill were not to pass, we would be okay because it's going into a general revenue account called the rainy day fee, so at the state budget office, so we would be okay.
So we'd have the money in.
We would have the money in there.
But we wouldn't be subject to the assessments that agencies will have to suffer under the bill that we're going to consider.
Correct.
All right.
Correct.
Thank you, sir.
The lady from the 50th, Doggett Longstreth.
Thank you, Mr. Speaker. Would the chairman yield for a question?
Yes.
I appreciate this, that we're putting something into the PEIA Rainy Day Fund, but is this just a 1 year that we would have to vote each year to put something into this fund?
This is just 1 year, and this is actually for fiscal year 2021.
2021?
We're putting money ahead of time for fiscal year 2021.
So there, the PEIA is covered for this next coming year and the year after?
Yeah,
Is that
there's
what you're
been no
saying?
premium increases to 2019, the current plan that we're in, nor is there any increases in fiscal year 2020.
Okay, but this will not be a permanent fix at this point. This is
That's
just...
correct.
Thank you.
The gentleman of the 30th, Doggett Bates.
Thank you, Mr. Speaker. Will the gentleman continue to yield? I just want to, this is an elegant arrangement. I think it was referred to upstairs as by my fiery friend in the corner as a money laundering scheme. But so this is not new money for PEA. This is actually old money for PEA. This is a supplemental appropriation for this fiscal year.
This is money coming from the 2019, the current fiscal year that we're in revenue surplus.
Okay. And so then we're going to take that, and then the secretary is going to actually send it out to the general revenue agencies.
That's correct.
And then the bill that's going to follow here shortly, the 3199, I believe.
3139, I believe.
Sorry. Then creates a mechanism where we're sending them a check and a bill at the same time.
Exactly.
And so then that money goes back
To help offset the assessments.
the assessment into this rainy day fund that's outside of the reserve in the PEIA ledger.
Exactly.
And then as part of the secondary bill that we're looking at shortly, there is an assessment that will go out to the special revenue agencies and those not covered under general revenue that isn't allocated for anywhere at this particular time. Is that correct?
You're correct.
And that's in the amount of an additional $45 million.
$45 million, you're
Okay.
correct.
And I think upstairs we heard some concerns about the fact that that would be money that some of these special revenue agencies would have difficulty being able to locate funds for. Some of them will be able to pass that fee on to...
It's possible. I mean, I can't answer what difficulties each
they may or may
agency
not have.
That's right.
But would it be true to say that we did hear upstairs some concern from our higher education institutions in particular, that they had some concerns about their ability to be able to locate the money to be able to pay this fee?
That's why it's important to pass the supplemental
Yes.
now.
Yeah, so this supplemental doesn't assist with that. It helps with just the general revenue folks.
That's right.
Thank you. Thank you, Mr. Speaker.
Does the gentleman from the 67th, Doggett Doyle?
Thank you, Mr. Speaker. Will the chairman continue to yield? You say this is a supplemental appropriation of money from the surplus in the current fiscal year or the recently completed fiscal year?
Current year, fiscal year
Current year.
19.
I realize this question might sound like heresy in some quarters, but suppose the economy tanks and we don't have a surplus.
What the governor did, he raised the revenue estimates 142 million. There was 58 million left that we did not spend last year. You had a combined balance of $200 million. This body has been passing several supplemental appropriations from this 200 million. This is one of the last ones.
I didn't hear an answer to my question, sir. What happens if the economy tanks and we don't have the money?
Right now, he's counting on the money right now, so.
All right, thank you.
Yeah.
Does the gentleman wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those elected having voted in the affirmative, the chair declares the bill passed. Clerk will please report the title.
House Bill 2665.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Lady from the 49th.
Mr. Speaker, I move the bill take effect from its passage.
The lady from the 49th moves that the bill be made effective from passage. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. Of this question, there are 99 ayes, 0 nays, 1 member absent, not voting. 2/3 of those elected having voted in the affirmative. The chair declares the bill effective from passage. The clerk will please communicate the action of the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2670 relating to damages for medical monitoring.
The gentleman from the 27th, Doug Schott, to explain the bill.
Thank you, Mr. Speaker. Currently in West Virginia, if you are exposed to a harmful substance that has some connection to future medical problems, you can bring an action even though you haven't actually experienced those problems that will allow the court to award money to provide for some monitoring of your condition to determine whether the exposure to that substance has created a future problem. What this bill does basically is simply address the administration of the funds that are awarded. It provides that in any action in which the court orders a defendant to pay for a plaintiff's future medical surveillance or future screening test or future monitoring procedures, no plaintiff shall be awarded or paid any monies to cover those costs until the tests, the surveillance, or the procedures have actually been completed. The court may allow or order the defendant to make periodic payments into the fund that's established to pay the cost of those future medical tests. And the court may also determine the date after which the future medical tests, surveillance, or monitoring are no longer required, and that any funds remaining after that date shall be repaid to the defendant. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. Of this question, there are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2670.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2703 relating to refunds of excise taxes collected from dealers of petroleum products.
The gentleman from the 10th, Doug Chris, to explain the bill.
Thank you, Mr. Speaker. Good morning again. This bill removes the cap on the amount of tax that may be refunded to a dealer of petroleum products for gallons lost due to evaporation. I urge passage. Thank you.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. Clerk will please report the title.
Committee substitute for House Bill 2703.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. For what purpose does the gentleman from the 28th seek recognition? Clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 2760, relating to performance reviews of state agencies and regulatory boards.
The gentleman 28th Delegate Pack to explain the bill.
Thank you, Mr. Speaker. This is House Bill 2760. The purpose of the bill is to include a review of agency or regulatory board rules and fees set by rule when the legislative auditor conducts performance reviews to ensure that the agency or board is not exercising improper powers or exceeding their statutory authority. The legislative auditor may make a recommendation to the rulemaking and review committee to review the agency or board rule when the auditor finds improper procedures or inappropriate fees. Mr. Speaker, I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 1 nay, 1 member absent not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 2760.
Are there amendments to the title? If not, the title as read, but the clerk will read and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2802, Uniform Partition of Heirs Property Act.
The gentleman 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. As you can tell by the title, this is a uniform act. It's called the Uniform Partition of Heirs Property Act. The Uniform Act has been modified somewhat to address the unique features of West Virginia mineral law. What the bill seeks to do is to seek to prevent family wealth from being acquired by an outside investor without first providing the family an opportunity to keep the land. Currently, co-tenants have the legal right to partition any property. A partition in kind physically divides the property into shares. A partition by sale sells the property as a single parcel and divides the proceeds. Partition by sale is regularly used with severed mineral estates. And here's where the problem arises. An investor may acquire a small undivided share, file a partition action, force the sale of the entire property against the wishes of the other owners. Usually this type of investor has substantial financial means and can outbid the other members, the other owners of the property. What this bill does is provide to the family a series of due process protections. First, notice. Second, appraisal. Third, the right of first refusal. Fourth, the right to a private auction. And finally, a right to a commercial sale. The act only applies to heirs property. In other words, one or more co-tenants must have received their interest from a relative. If a property is not heirs property, the current partition statute will apply. There are two key exceptions to this bill. First, the current partition statute will remain applicable to severed coal, not this new bill. Second, the current partition statute will also remain applicable to a severed oil and gas estate if the co-tenancy reform law that we passed last session does not allow for development and the developer has made reasonable, good faith efforts to acquire the needed leases. If oil and gas development through co-tenancy reform is available, the new bill will apply to the severed oil and gas rights. In summary, the bill attempts to preserve the rights of co-tenants to partition their interest in family real estate while ensuring that the other co-tenants will have the needed due process rights to prevent a forced sale to an outside investor. Finally, the bill contains language to protect co-tenants from losing an oil and gas interest to a forced sale if the interest is covered by a valid lease. This is to protect those individuals who are willing to allow development. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? The gentleman from the 55th, Douglas Spinagle.
Will the chairman yield for a couple questions?
Sure.
For surface rights or property and fee under Chapter 37, Article 4, does this affect that in any way?
Yeah, yes it does.
Okay. Can you explain how it affects that particular, for the surface right owners? What changes current partition law versus what this bill attempts to do for surface?
For just surface where the minerals have been severed, is that correct?
Well, if I own the property, well, let's say co-tenancy with another individual, and the minerals have been severed, and does the current
Chapter 37, Article 4, say we get in an argument, myself, we're not worried about the mineral rights, we're worried about the surface rights. Does this bill affect that in any way?
If it's heirs property, in other words, one of you acquired your interest from an heir, yes, it would govern that as well. And the same protections would be available to both owners.
So typically the procedure is, let's just say we have 3 owners of surface rights, and one of us wants to sell it. We've fallen out amongst ourselves. The current law, which has been on the books for 100 and some years, and a lot of case law on this, is that you try to divide it in kind, meaning if you can lay it out among you equally, the value of the property. And if the property cannot be divided in kind, then you would have a partition sale, and the court would authorize commissioners to sell it. They're special commissioners. They'd sell it at the courthouse steps. You get the value, and then after cost and liens and everything are paid off, that money gets divided out amongst the owners. How does this bill affect that?
I think, give me just a minute to make sure, but I think the result could be the same, but not necessarily. There's a right of first refusal involved in this. The simple answer is there's more protections. If you go through the statute and you meet each of the criteria, the 20% test and so forth, and it becomes heirs property, there are more due process rights that substitute an appraisal for the commissioners. As you know, the commissioners may not have any expertise in real estate values, for instance. So you would likely have with the appraisal more protection with respect to the valuation of the property. The current statute would not give the family members the right of first refusal. In other words, it could be forced sale to the outside party, whereas once the valuation is determined by the appraisal, then those who are not seeking the partition would have the right of first refusal to pay that value, whereas under the current statute, they could be forced to go to a public auction.
What if the appraisal, let's just say this tract of land, the appraisal came in at $200,000, and typically you're never going to get an appraisal value when it's sold. And let's say the value gets sold at the courthouse steps at $100,000. How does the court approve that when you have an appraisal that says it's worth $200,000 but it was sold at $100,000? Does that cause any problems?
The court would set a reserve price below which the property could not be sold. And then you'd have to, assuming you couldn't get that price, you'd have to go back to the court, get them to revise the reserve price. Reserve price is intended to protect the other owners. But the court could revise that price down, that reserve price, based on what the market value is, how the market value is reflected by the public sale. But the right of first refusal would allow those individuals to protect themselves, the other heirs or the other co-tenants to protect themselves from actually having that public auction if they were willing to pay that price.
The reserve price? So what you're saying that the reserve price?
The appraised price would be the first right of refusal would apply to the appraised price.
Okay.
But they don't have to exercise that right. It's an optional right.
Okay, thank you.
Sure.
The gentleman at 36, Doggett Rowe.
Yield for question.
Yes.
As I read this bill, it talks a lot about gas and oil leases, but does it cover other kinds of property? Just regular
If it's
real estate, the mom's house, and the heirs are in contest over that?
If it's determined to be heirs property, and you'd have to go through the criteria to determine that, but one of the things it's intended to do is protect family farms and that sort of thing. So yes, it would. It doesn't necessarily have to apply to mineral estates.
Thank you, sir.
The gentleman at 46, Doggett Martin.
Thank you, Mr. Speaker. Would the chairman yield for another quick question? I was trying to follow along there, but in judiciary, we discussed that if I'm living on a property with multiple owners, and I would want to, decide, hey, I want to buy this house or buy this farm, that if I would push for the partition, then I would not be able to bid on the property. Has that been fixed?
If you're the plaintiff, the person seeking partition, the others would have the superior rights to the property. In other words, the right of first refusal and so forth. So to answer your question, possibly not. And if the others, the idea is to protect those who want to stay there and don't want to sell or want to preserve the family farm would have that opportunity.
So if I'm living on a farm and I own, a large portion of it, but my other family members own part of that farm, and I would want to say, hey, I want to own 100% of this farm, this would prevent me from having first right to, or maybe not first right to refusal, but would I be able to go to the courthouse and bid on the property just like the other ones because I pushed for the partition?
Well, of course, first of all, you'd always have the right to seek to buy them out voluntarily. But the question I think you're asking, if they refuse to sell, then do you have the right to seek partition? You do have the right to seek partition, but because they don't want to sell, they have certain rights under this law to protect themselves, including the right of first refusal once the price is determined by appraisal.
So if we also talked about appraising the minerals, that we didn't really know of anybody that appraised those minerals. Is that something that is pretty common for somebody to come and appraise those minerals and say, hey, this is how much this property, your farm and your...
There are people who do that. I don't know if I'd describe it as common. I don't think you find them on every street corner, but there are people out there that do that. I'm not going to tell you it's cheap, but there are specialists that will appraise minerals and provide an estimate of value.
So how would the court know how would they set, the appraised value? Would they just go off of the information that is provided to them?
Usually there's a hearing. I mean, the bill anticipates that there's a hearing and an expert would come forward and present that information. It can be challenged like in any type of adversarial proceeding. If you don't like the results, you could get another expert to provide information, or you could provide, for instance, in the case of land leases, you probably have data that's available, documentation in the local courthouse that you could present to show valuation. So yeah, you would have the ability to challenge that value. The court is not required to accept the appraisal.
Okay, so under current law, if you're living on the property with multiple owners, you push for partition, then you would be able to bid on it, and this would change that, or that's not changed?
Under the current law, essentially, if a petition is filed and the property goes to sale on the courthouse steps, the person with the most money that wants it the most can buy it.
Okay. All right. Thank you.
Sure.
Does the gentleman 27th wish to close debate on the bill? If not, the gentleman 35th, Doug Capito.
Thank you, Mr. Speaker. I'd request a Rule 49 as my employer does own leases in the state of West Virginia.
Under that factual situation, as just described by the gentleman, you would be a member of a class of greater than 5 and would therefore be directed to vote. The question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 86 ayes, 13 nays, 1 member absent, not voting. Majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2802.
Are there amendments to the title? If not, the title is read, but the clerk will be enumerating the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2831, finding and declaring certain claims against the state and its agencies to be moral obligations of the state.
The gentleman of the 64th, Douglas Householder, to explain the bill.
Thank you, Mr. Speaker. The bill directs payment of moral obligations of state agencies approved by the West Virginia Legislative Claims Commission for claims against the state which, but for the constitutional immunity of the state from suit or other legal restriction, could be maintained in the regular courts of the state and have been determined by the Legislative Claims Commission to those that the state should, in equity and good conscience, discharge and pay. The total amount of the claims itemized in the bill is directed to be paid from various state funds as follows. General Revenue Fund, $460,512.67. General Revenue Reappropriated Funds, $106,378. State Road Fund, $2,703,145.61. Special Revenue Fund, $212,742.70 for a grand total of $3,482,778.98. I urge passage.
The question before the House is, shall the bill pass? The gentleman of 32nd, Douglas Fast.
Thank you, Mr. Speaker. I request a Rule 49 ruling in that I have a client that is one of the named proposed recipients under this bill.
The gentleman actually represents a client named to be paid in the bill?
Yes.
Under that factual scenario, the gentleman would be excused from voting and is directed not to vote. The gentleman of the 35th, Douglas Nelson.
Yes, thank you, Mr. Speaker. Would the chairman yield?
Yes.
Thank you. How does this total number compare to past years as far as our trend?
I'm informed by council that this year the State Road Fund is much larger than last year's.
And would you attribute that to maybe the conditions of our roads?
You could contribute to whatever you see fit. I'm not really sure how you would contribute that to. It could be.
There is one rather large item on page 15, item 174. It's a $1.3 million line item or payment. Can you give the body a little background on what that may be?
It's on page 15. What line item?
It's item 174. $1.3 million. Is it page 13? Okay. On the
What's the quicker next? Counsel informs me that it was a serious bodily injury, but the court had stipulated this amount to both parties of $1,295,332. That's all I know.
Okay, thank you. And last question. The abstract notes suggested amendments of 3 claims looking back to 2016. Can you provide a little information of what those claims are and why we were amending something that a prior body maybe didn't approve?
It's payable from the State Road Fund, Martha Moyers, $42,750. Stephen Mowish and Deborah Mowish, $215,000. And Christian Life Center in the amount of $8,500.
That is, I guess, a little different as far as going back to claims of the past that this body voted on and putting it in a bill this time, is it not?
Not necessarily, no.
In any particular
it's still more
background that you can give the body as to why we amended this into this bill?
The only thing that I can tell you, it was a moral obligation that the state needed to pay.
But you do agree that these items were not approved in prior budgets?
They could have been overlooked in prior budgets by mistake.
You do remember that we did vote against these in a prior budget?
I don't really recall.
Okay. I believe we do, or did, but thank you, Mr. Speaker. Thank you, Chairman.
The gentleman of the 35th, Douglas Byrd.
Thank you, Mr. Speaker. Same request, Rule 49. My law firm has a matter pending with the Court of Claims.
The gentleman's firm represents a client proposed to be paid under the bill?
Yes.
The gentleman would also be excused from voting.
Thank you.
Are there other members who wish to speak to the passage of the bill? If not, the question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 91 ayes, 6 nays, 1 member absent not voting, 2 members directed not to vote pursuant to Rule 49. Majority of those having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2831.
Are there amendments to the title? If not, the title as read by the clerk will be entered the title of the bill. The lady from the 49th.
Mr. Speaker, I move that the bill take effect from its passage.
The lady from the 49th moves that the bill be made effective from passage. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 96 ayes, 1 nay, 1 member absent, not voting, 2 members directed not to vote pursuant to Rule 49. 2/3 of those elected having voted in the affirmative, the chair declares the bill effective from passage. Clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 2850, relating to qualifications for a commercial driver's license.
The gentleman from the 28th, Ellicott Pack, to explain the bill.
Thank you, Mr. Speaker. This is House Bill 2850. This bill allows individuals who are at least 18 years old and have held a valid Class E or Class D driver's license to apply for a commercial driver's license instructional permit once he or she has held a Class E or Class D license for 1 year, currently in code that requires them to hold that license for 2 years. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 2850.
Are there amendments to the title? If not, the title is read, but the clerk will read and remain the title of the bill. The clerk will please communicate the action to the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 2853, establishing the West Virginia Program for Open Education Resources.
The gentleman from the 48th, Ellicott Hamrick, to explain the bill.
Thank you, Mr. Speaker. This bill establishes a program for open education resources under the West Virginia Library Commission to encourage and facilitate the use of open education resource materials in both higher education and public schools. Open education resources are materials in any medium, digital or otherwise, that reside in the public domain or have been released under the open license that permits low-cost access, use, adaptation, and redistribution by others with no or limited restrictions. In consultation with the higher and public ed, the Library Commission is to ascertain institutions or faculty currently using open education resource material, identify material associated with the core courses and readily available, identify impediments which interfere with the selection and use, identify potential grants and propose a competitive application, establish a digital publicly accessible database for material, develop strategies to leverage further open resource material, and report annually on findings, progress, and recommendations. Mr. Speaker, I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 99 ayes, 0 nays, 1 member absent, not voting. Majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 2853.
Are there amendments to the title?
Delegate Hamrick moves to amend the title.
Question before the House is the adoption of the title amendment. Those in favor will say aye. Those opposed will say no. Ayes have it. Chair declares the title amendment adopted. Title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2866, relating to the termination, expiration, or cancellation of oil or natural gas leases.
The gentleman, the 27th, Ellicott Schott, to explain the bill.
Thank you, Mr. Speaker. This bill encourages a constructive dialogue between oil and gas owners and the oil and gas developers regarding the status of oil and gas leases. The bill also seeks to provide a mechanism where oil and gas owners can acquire a recordable release from their lessees for expired, terminated, or canceled oil and gas natural gas leases. The process aims to clear mineral titles or to provide the parties a better understanding of the status of an oil and gas lease. The bill provides that within 90 days of an oil and gas lease becoming invalid, the lessee must provide the lessors with a recordable release. If a recordable release is not provided within 90 days, a lessor may serve notice on all of the current lessees of their legal duties to provide a release. The notice must also contain certain information, including the identification of the land, identification of the lease, and statements about the invalidity of the lease, the lessor's rights, and the lessee's legal obligations. After service of that notice has been attempted in person by certified mail or if those means are not available by publication, a lessee has a second 90-day period to respond to the lessor and to provide either the release or a written challenge disputing the invalidity of the lease. After the notice period, if a release or response is not received, a lessor may record in the county where the land is located an affidavit containing certain defined information similar to what is found in the notice. The bill then requires the county clerks to record the affidavit under the names of the original lessors, the original lessees, all the current lessees, and the lessors seeking the release. Only the identified lessors seeking the release will have their title interest affected by the affidavit. Finally, in order to encourage free communication between the parties, language is included in the bill so that neither the lessees nor the lessors' writings to each other will limit or waive any claim or defense of the parties in law or at equity. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? The gentleman of the 7th, Douglas Harshbarger.
Thank you, Mr. Speaker. I ask for a Rule 49 due to my employment in the natural gas industry.
Does the gentleman in the 35th seek a similar ruling pursuant to Rule 49?
Yes, sir, Mr. Speaker.
It is Chair's understanding that both gentlemen are employed by employers which have some connection to the natural gas industry and therefore would be members of a class of greater than 5 individuals and therefore would be directed by the Chair to vote. Are there members who wish to speak to the passage of the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 95 ayes, 4 nays, 1 member absent, not voting. Majority of those present having voted in the affirmative, the Chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2866.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Lady from the 49th.
Thank you, Mr. Speaker. The House will stand in recess for 10 minutes and 10 minutes only.
Is there objection to the lady's request that the House stand in recess for 10 minutes? Chair hears no objection. The House is in recess until 11:03 a.m.
I'm going to run.
House will please come back to order. Next bill on second reading. Third reading.
Committee substitute for House Bill 2895, allowing victims of certain crimes to get a restraining order.
The gentleman from the 35th, Doug Capito, to explain the bill.
Thank you, Mr. Speaker, and welcome back, ladies and gentlemen. This bill has to do with certain crimes and restraining orders. It's actually derived from a situation where the perpetrator of a certain crime purposefully moved into and actually next door to the victim of that crime. And there was really, there was no resolution or no relief that the victim in that scenario could have sought. So what we're doing with this bill is we're providing a remedy to the victims that are in similar situations. And what we do with this bill is we provide the court the option of issuing a restraining order against the perpetrator of a crime who knowingly initiates contact with the victim of that crime. The restraining order prohibits a perpetrator from establishing a residence in proximity of the victim. But I would note that this only applies to residences established after the perpetrator is convicted of the crime. So if that perpetrator had a residence in that proximity prior to the crime being committed and the conviction coming down, this would not apply. The court also has to find, before it issues the restraining order, it must find that the proximity of the perpetrator to the victim would cause the victim emotional distress. And I would also note that in committee we amended this bill to ensure that it's permissive upon the court. So the court's not required to issue the restraining order. It may issue the restraining order if it finds the appropriate findings. Thank you, Mr. Speaker. That's the bill. I urge its passage.
The question before the House is, shall the bill pass? The gentleman from the 55th, Douglas Spinagle.
Just a couple quick questions, just reading it. What's residence in proximity? What's the distance of that? Is that?
Discretion with the court.
Discretion of the courts. There's no established 100 feet, 1,000 feet, in the same neighborhood, a mile. We don't know what the distance is.
It's not defined in the bill.
Okay. And the time period, how long can the court issue a restraining order? In perpetuity or 6 months, a year?
Discretion of the court.
Okay. And the way it reads there, upon finding that the convicted person subsequent to his or her conviction established or intends to establish their residence could be there prior if it's established, right?
Correct, and I think, and tell me if I'm not hitting your question on the head here, but as I mentioned, the residence would have to be established after the conviction. So if the residence was established prior to the conviction, then this would not apply.
Okay, so using that, you're saying if it was established prior to that, say they're next door neighbors, for example, the court couldn't issue a restraining order to put them out of their house.
If they're coming home to the home, yeah, exactly.
Okay, thank you.
Mm-hmm.
Are there other members who wish to speak to the passage of the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 0 nays, 2 members absent not voting, a majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2895.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2931, clarify that State Lottery Commission has no authority over non-lottery games.
Lady in the 49th.
Thank you, Mr. Speaker. I ask unanimous consent to postpone action one day.
Lady from the 49th asks unanimous consent that further action on committee substitute for House Bill 2931 be postponed one day. Are there objections? Objection is heard. Question before the House is the motion by the lady from the 49th that action on committee substitute for House Bill 2931 be postponed one day. Those in favor will say aye. Those opposed will say no. No. Ayes have it. Motion further action is postponed one day. Next bill on third reading.
Committee substitute for House Bill 2943 relating to deliveries by wine specialty shop.
Gentleman of 35th, Dr. Capito, to explain the bill.
Thank you very much, Mr. Speaker. This bill allows our wine specialty shops in West Virginia to make deliveries to homes. Included in those deliveries are gift baskets, including wine and wine alone. It does not require a license from the ABC, and that's essentially the purpose of this bill, is to allow delivery of wine to as gifts. And there are certain restrictions put on the bill, and the wine can only be delivered either within the county or within 50 miles of the shop, so long as the delivery is not out of state or to a dry county. The alcohol must be purchased in person, obviously by a person of age. This will allow our local farmers markets and wine shops to, I think, to have some prosperity, Mr. Speaker. I think this is a good bill, and I would urge its passage.
Question for the House: shall the bill pass? The members wish to speak to the passage of the bill. If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 91 ayes, 7 nays, 2 members absent, not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2943.
Are there amendments to the title? If not, the title is read by the clerk will be and read the title of the bill. The clerk will please communicate the action of the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2945 relating to vendors paying a single annual fee for a permit issued by a local health department.
Gentleman from the 10th, Doug Chris, to explain the bill.
Thank you, Mr. Speaker. Good morning again. The purpose of this bill is to provide greater freedom to vendors selling non-potential hazardous food products at temporary locations for fairs, festivals, and events, similar activities, while still regulating the safety of the food being sold. Under the committee's substitute, vendors' permits for non-potential hazardous foods will be good for a year and may be used in counties adjoining the vendor's county of residence or 25 air miles, whichever is greater. Non-potential hazardous foods do not require time or temperature control for safety to limit microorganism growth or toxin formation. Examples of the foods such as popcorn, peanuts, kettle corn, and bottled beverages. The law requiring potential hazardous foods will remain unchanged, and each local or county health department may continue to require separate permits or fees for these events. Examples of potential hazardous foods such as meat, fish, and poultry. The committee substitute requires each vendor provide notice to the local health department at least 14 days prior to the start of the event. The other health departments may place limitations on the issue of permits to assure compliance with local rules for the type of permit. The permit will also be visible, posted, or is not valid. Mr. Speaker, I urge passage.
The question for the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2945.
Are there amendments to the title? If not, the title as read by the clerk will be and read the title of the bill. The clerk will please communicate the action of the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2974 exempting businesses relating to transporting certain used tires to storage, disposal, or recycle locations from provisions of chapter.
For what purpose does the gentleman from the 67th seek recognition?
To introduce a former member. Over against the wall, the Honorable Mark Harmon.
The gentleman from the 56th, Douglas Howell, will explain committee substitute for House Bill 2974.
Thank you, Mr. Speaker. This bill exempts common carriers or contract carriers engaged in the business of transporting scrap tires, waste tires, and other used tires to storage, disposal, or recycling locations from the Public Service Commission regulation. The bill also exempts motor vehicles under the Department of Environmental Protection for the cleanup and transportation of tires and solid waste created by the state-authorized cleanup projects. I urge passage.
Question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, the gentleman from the 13th, Dr. Cato.
Thank you, Mr. Speaker. I know we went through a good bit of argument yesterday, but this is not going to clean up the tire situation. I believe the only thing that's going to happen, because it costs money to get rid of tires, and the tires, you know, the only way we can do this, in my opinion, is create a bill to people that change tires. You're going to have to force them to dispose of tires. They're going to have to, in other words, if you go to a gas station and get your tires changed, you can take those tires home with you. And that's how we get all these tires in places where they don't belong. And also, when people haul these tires, when everybody can haul these tires, we'll see more tires along in a ditch or a strip mine or wherever. The reason we have authority to haul in trucking business is to regulate who does the work. And people in trucking have to have a minimum $750,000 insurance. And they have to have drug testing programs. Now, you let everyone haul these tires, they're not going to be drug tested, and they're going to use a pickup truck with bald tires pulling a trailer that's overloaded and hit somebody and kill them. Then you've got the minimum, if I remember right, insurance requirements are $50,000 on a personal vehicle, something like that. 25, okay, it's 25,000. All right, so this guy's got $25,000 insurance. He hit somebody head on and killed him, or somebody pulls out in front of him. He can't get stopped because he don't have brakes on his trailer and he's overloaded. So things are regulated for a reason, and I am voting no on this bill. So thank you, Mr. Speaker.
Are there other members who wish to speak to the passage of the bill? If not, does the gentleman wish to close debate on the bill? Question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 59 ayes, 40 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2974.
Are there amendments to the title? If not, the title is read, but the clerk will be in the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2991, re-adding to the Ryan Brown Addiction Prevention and Recovery Fund.
Gentleman to 27, Doug Ellington, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to expand the treatment and recovery services options which may be subsidized using this fund. Those services will be determined by an assessment performed by the Office of Drug Control Policy. The Governor's Substance Abuse Council will also review that assessment and prioritize how the money should be distributed or allocated. Before any money may be spent, the prioritized list shall be presented to the Joint Committee on Government and Finance. Additionally, any new settlement or judgments with a drug manufacturer, wholesaler, or retailer are required to have any net proceeds recovered for the state to be placed in the Ryan Brown Addiction Prevention and Recovery Fund. Mr. Speaker, I urge passage.
The question before the House is, shall the bill pass? The gentleman to the 60th, Doug Wilson.
Thank you, Mr. Speaker. May I address the bill?
Gentleman may proceed.
Thank you, sir. I rise in opposition to the bill. The fact of the matter is that the Ryan Brown Fund can receive donations, can receive support, can receive monies from other areas, can receive funds from a variety of areas, whereas the Attorney General's office to their ability to investigate and maintain civil actions, the principal means for funding that is this particular fund. And if we pass this bill, we could severely debilitate the office's ability to investigate and maintain civil actions. Any bill that reduces the state's ability to fight the opioid epidemic, protect senior citizens from fraud and abuse, and aggressively pursue those who prey on our most unguarded West Virginia citizens is not a good idea. Thank you, sir.
The gentleman to the 17th, Doug Rohrbach.
Thank you, Mr. Speaker. I'm going to get up and speak very much in favor of this bill. What we heard on committee is we have built or in place, we went from this fund's formation, 100 beds in this state, to almost 1,000 currently. What we've been asked for is to have DHHR have some flexibility in how they use this money, more for treatment and recovery beds. Now, in regards to the gentleman's from the Eastern Panhandle's comments about the Attorney General Settlement Fund. Folks, if we're going to get in here and rail about opioid manufacturers, but we're not going to put any of these settlements towards this, minus expenses, then we need to stop railing about the manufacturers of the opioids. So I'm going to urge people to vote for this. Let's put the money where the money belongs, in treatment to get our state recovered from this epidemic. Thank you, Mr. Speaker.
The gentleman at 36, Doug Robinson.
Thank you, Mr. Speaker. Will the chairman yield?
Chairman does yield.
Yes, sir.
Thank you, Mr. Chairman. What's the amount of private donations the Ryan Brown Fund has received to date?
My understanding is we don't have any at this time.
None. It was created 2 years ago.
It's created 2 years ago, yes.
We've gotten $0.
Right. Only monies that I'm aware of would be from previous settlement from the pharmaceutical industry, and also money that was appropriated from the legislature.
Okay. And then the gentleman from 60th had some concerns about cost shared by the AG or the Attorney General. You had an amendment yesterday that actually, let's see, it allows state agencies to recover reasonable administration costs, contractual damages, or expenses in the pursuit of the litigation prior to the proceeds being transferred to the fund. Would that include costs incurred by the Attorney General?
That could be part of that.
Okay.
Most of the other costs would be that the DHHR would have to pay to their agencies in the litigation that they would have to do.
So his concerns really aren't relevant once that amendment goes in, correct?
Well, I don't have any control over that part, but I'm assuming that it would be reasonable expenses that they used.
You don't want to worry about the concerns that the gentleman has?
The Attorney General has to answer to the governor, and obviously the governor answers to us, so.
Thank you, Mr. Chairman. Speak to the bill.
Gentleman may proceed.
This bill was created 2 years ago. It came from the finance chair at the time. The bill was created. There's somewhere around $20 million, $22 million, I believe, is the close number. Nearly 500 beds have been created to this point, and I believe with this legislation, we'll be able to see more funds go in there. The fund is depleted. There's no money left. The last $1 million that was returned by a company was actually allocated to Thomas Hospital in Kanawha County, the first one to be developed in Kanawha County. The rest have been in the governor's regions there. I agree with the bill. I think we need to find more opportunities to put funding in areas like this, and I would suggest a green vote on this bill. Thank you.
Does the gentleman from the 27th wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 93 ayes, 5 nays, 2 members absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2991.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 3016 relating to the State Aeronautics Commission.
The gentleman, the 14th, Douglas Butler, to explain the bill.
Thank you, Mr. Speaker. The committee reported a committee substitute which incorporated the amendment of the Committee on Government Organization as reported on first reference. The committee substitute would repeal 12 existing codes that govern the activities related to the jurisdiction of the State Aeronautics Commission and amend 11 related existing code sections. The amended sections would revise definitions, revise criteria for fitness to serve on the commission, establish quorum requirements, and allow meeting participation by phone, require the publication of certain information in possession of the commission, and the sufficiency of certain publications, remove provisions relating to location of commission offices outside Charleston, require the advice and consent of the Secretary of Transportation before the governor's appointment of the Director of Aeronautics, revise criteria for fitness to serve as director, allow the Secretary of Transportation to set salary of director rather than the commission, exclude the requirement that the chairman of the commission is also executive to all contracts entered into by the commission, remove provisions allowing the commission personnel to make available the engineering and other technical services of the commission without charge to any person desiring them in connection with the construction, maintenance, and operation of any airport, and remove language that financial assistance from appropriation of the legislature to the commission and made available for certain purposes may be furnished in connection with federal and other financial aid for the same purposes. As recommended by the Committee on Government Organization, the committee substitute would also amend sections relating to relating to DUI while operating an aircraft, license requirements for operating an aircraft in the state, and duties of law enforcement officers to assist in enforcement of this article of code. The committee substitute would also restore the code rather than repeal the following sections. And there's a whole list of sections here. They're 29.2A10, public purpose of activities, 29.2A11A, implied consent to tests, 29.2A11B, preliminary analysis of breath to determine alcoholic content of blood, 29.2A11, how blood tests administered, 29.2A11D, interpretation and use of chemical tests, 29A11E, right to demand a test, 29.2A11F, fee for withdrawing blood sample, 29.2A12, operation of aircraft at low altitude, 29.2A13, unauthorized taking or operation of aircraft penalty. Finally, the committee substitute would continue to repeal the 12 code sections attached, and there's a whole bunch of stuff here that I don't think we need to get into. This bill was requested by the Department of Transportation, the Aeronautics Commission, and I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 98 ayes, 0 nays, 2 members absent not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 3016.
Are there amendments to the title? If not, the title was read, but the clerk will bring and the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3020, relating to sole source contracts for goods and services with nonprofit corporations affiliated with the respective education institutions.
The gentleman of 66, Douglas Espinoza, to explain the bill.
Thank you, Mr. Speaker. House Bill 3020 would allow an institutional governing board, the Higher Education Policy Commission, or the Community and Technical College Council to enter into a contract for materials, goods, equipment, services, printing facilities, or financial services with an affiliated nonprofit corporation. In so doing, the affiliated nonprofit corporation shall be deemed a sole source in respect to any applicable law or regulation relating to the expenditures of public funds. As a university official pointed out who assisted with the crafting of this legislation, most of our colleges and universities have an affiliated 501c3 whose sole purpose is to provide support to that college. The legal relationship puts the 501c3 in a unique status. Everything it does must be in support of that college or university. The statutory recognition of that 501c3 as a sole source will allow that college or university to do specific financial transactions with its 501c3 whose sole purpose is to support that school. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? The gentleman of 36, Douglas Rowe.
Would the gentleman yield?
Gentleman does yield.
I'm just wondering what the scope of this is. As a sole source, that means that the university or college can contract with that one company disregarding any bidding requirements whatsoever, correct?
Well, just a moment. This transaction would still be subject to audit, specifically in the legislation. They must have annually independently audited financial statements, which have been included and presented for at least the preceding 5 years in the audited financial statements of the respecting governing board or of the respective institution of higher education under the authority of a governing board or the commission or council. All these transactions would, again, be subject to review by the auditor and would also be public record.
Yeah, but this, my question really is doesn't this dramatically change the purchasing practices of higher education? Because by deeming any nonprofit, as I understand it, it's not, maybe that should be another question. Is the nonprofit only a nonprofit that might be an organization solely serving the university, or is the nonprofit any 501c?
It has to be an affiliated nonprofit corporation.
Okay, now how is it affiliated?
I'm sorry?
How would it be affiliated? Would it be institutional advancement, special corporation that the university owns, college owns? I see the term affiliated, but I don't see it. Is it defined? It's on line, let's see, 13 in the first section.
Yeah, line 13, as you point out, indicates that the college or university may enter into such a contract with an affiliated nonprofit corporation under such financial terms as the governing board, commission, or council determines are reasonable and proper.
So as we go on in that section, as I understand it, it's a nonprofit that has been organized by the institution, correct? To be
That's right.
affiliated.
If you continue on down the page on line 18, as used in this section, affiliated nonprofit corporation means a West Virginia nonprofit, non-stock corporation, which one is organized as for charitable, educational, and scientific purposes or for similar purposes, is recognized by the Internal Revenue Service as a Section 501c3 or successor provision of federal law, tax-exempt organization. Number 3 is organized solely to support and contribute to the respective institution. So I think that's the key. The respective institution of higher education or to the commission or to the council as applicable. And then number 4 picks up that language that I shared previously that has to have the annual certified audits.
So could the affiliated nonprofit go out and purchase services or goods and then provide them to the institution without a bidding process? Or is it just something that that organization itself does on a regular basis, day to day?
I don't think the bill really limits the use of those funds, but again, it's subject to audit. It's subject to audit, and it is a matter of public record.
But the idea is that we have an affiliated nonprofit, and it can deal with the university as sole source without bidding on its services. But we're not sure if they might subcontract out to particular providers and then come within the exception that's provided for the affiliated nonprofit.
I think the fact that the 501c3 is intended to provide support to that college, that's their message. I think that provides the protections that I believe my colleague is seeking, that, everything that 501c3 does has to be in support of that college or institution. So I believe that it provides, that unique relationship, I think, provides the necessary protections, but obviously that's a policy question.
But there's nothing certainly in the bill itself that prevents that affiliated nonprofit from subcontracting for services by perhaps favorite vendors or whatever. In other words, it takes the bidding process out even for a subcontractor of that affiliated. Or there's nothing in the bill to prevent it, at least.
Just a moment. The subcontractor is not addressed in this bill. This is solely the relationship between the college and the university and their affiliated 501c3.
Thank you, sir. Thank you, Mr.
Thank
Speaker.
you.
Are there other members who wish to speak to the passage of the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 95 ayes, 3 nays, 2 members absent not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. For what purpose does the gentleman at 66, Douglas Espinoza, seek recognition? The clerk will please report the title.
House Bill 3020.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 3021 relating to the disposition of permit fees, registration fees, and civil penalties imposed against thoroughbred horse racing licensees.
The gentleman of 66, Douglas Espinoza, to explain the bill.
Thank you, Mr. Speaker. House Bill 3021 would change the way certain civil penalties are imposed in thoroughbred racing activities are distributed. The civil penalties imposed on thoroughbred horse racing licensees or permit holders are to be paid into a fund and used for expenses associated with the post-mortem examination of thoroughbreds. Any balance in the fund at the end of any fiscal year in excess of $10,000, less any outstanding obligations, shall be divided equally and may be expended by the Racing Commission for two purposes. One, to aid in the rescue, retraining, rehabilitation, and aftercare of thoroughbred racehorses that are no longer able to compete on racetracks in this state. And secondly, to aid in the payment of hospitalization, medical care, funeral expenses occasioned by injuries or deaths sustained by a thoroughbred racing permit holder at a licensed thoroughbred racetrack in this state. Would note that all civil penalties imposed on greyhound racing licensees or permit holders are to be paid into a fund and used for greyhound adoption programs and are not changed by this legislation. Mr. Speaker, urge passage of the bill.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 89 ayes, 9 nays, 2 members absent not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 3021.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 3024, West Virginia Business Ready Sites Program.
The gentleman of 56, Douglas Howe, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to establish the West Virginia Business Readiness Site Program. The West Virginia Development Office will implement a pilot program to promote economic activity in certain areas of the state by facilitating the construction of utility infrastructure to increase the industrial development in West Virginia. An industrial development agency may apply to the Development Office for approval of an industrial development site. The application shall contain a description of the infrastructure program, a comprehensive financial report about the program, the projected number of new customers served by the program, a cost recovery mechanism, and any other information the Development Office finds relevant. Upon application, the Development Office will determine if the proposed site will accomplish the public purposes of the bill and certify the site to provide certification to the Public Service Commission. Upon PSC approval, utilities will be authorized to implement the infrastructure program and to recover the related incremental cost. Net contributions to recovery of return and depreciation of property taxes directly attributable to the infrastructure program provided by the new customers served by the infrastructure program investments. I urge passage.
The question before the House is, shall the bill pass? The gentleman of 35th, Douglas Byrd.
Thank you, Mr. Speaker. Will the gentleman yield? Thank you. Love the bill. One question, though. Was there any talk about how much this would cost to get it off the ground? The estimates I think we received in small business is $16 million. Was there any consideration of that?
We had no discussion at committee, and there was no fiscal note attached to the bill.
Okay. Thank you.
The question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 1 nay, 1 member absent not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 3024.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Lady from the 49th.
Thank you, Mr. Speaker. I move that the bill take effect from its passage.
Lady from the 49th moves the bill be made effective from passage. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 1 nay, 1 member absent, not voting. 2/3 of members elected having voted in the affirmative. The chair declares the bill effective for passage. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3044, requiring a Commissioner of Highways to develop a formula for allocating road funds.
The gentleman from the 56th, Douglas Howell, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to require the Commissioner of Highways to develop a formula for allocating road funds between the 10 DOH districts. Additionally, the bill requires the Commissioner submit the formula to the legislative rulemaking for approval during the 2020 regular session. I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. The gentleman 27th, Douglas Schott, your vote is not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 97 ayes, 2 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
House Bill 3044.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3054, relating to the State Agency for Surplus Property.
The gentleman, the 28th, Douglas Pack, to explain the bill.
Thank you, Mr. Speaker. This is House Bill 3054. The purpose of this bill is to permit that the state agencies for surplus property to require the state agency that is the current owner of the property to remove all livery and other features identifying the property as state property prior to its disposition. I urge its passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 1 nay, 1 member absent, not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
House Bill 3054.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 3057, relating to the Adult Drug Court Participation Fund.
Gentleman from the 10th, Dr. Chris, to explain the bill.
Thank you, Mr. Speaker. The bill will revise the language governing expenditures from the Adult Drug Court Participation Fund. Basically, we are taking a line item in the general revenue and setting up a special revenue account fund funded by the participants of the drug court. I urge passage. Thank you.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. Of this question, there are 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 3057.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3095, establishing a minimum monthly retirement annuity for certain retirements.
The gentleman from the 10th, Dr. Chris, to explain the bill.
Thank you again, Mr. Speaker. The bill would amend the provisions of the West Virginia Code relating to both the public employees' retirement system, PERS, and the teachers' retirement system. The bill would provide a minimum monthly benefit of $750 for the retirees or beneficiaries of the retirees of PERS or TERS that have 25 or more years of service. Current law provides a minimum monthly benefit of $500 for the retirees and that have more than 20 years of service. The bill also provides some exclusions. For PERS, service as an elected public official or temporary legislative employee would not be counted towards the 25 years of service requirement. For TERS, service as an employee of an institution of higher education when the employee's salary was capped at $4,800 would not be counted toward the 25 years of service requirement. These limitations are similar to the limitations in current provisions, providing a minimum monthly benefit of $500 for the retirees with 20 or more years of service. I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 99 ayes, 1 nay, 99 ayes, 0 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 3095.
Are there amendments to the title? If not, title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3102, creating alternating wine proprietorships for wineries and farm wineries.
The gentleman from the 66, Douglas Espinoza, to explain the bill.
Thank you again, Mr. Speaker. House Bill 3102 permits alternating wine proprietorship agreements so long as each business meets the requirements of a winery or a farm winery under federal and state law to rent or lease wine production facilities, equipment, or space on the licensed farm winery's premises, and the parties to an alternating wine proprietorship agreement maintain separate businesses. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 94 ayes, 5 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 3102.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 3105, permitting the Alcohol Beverage Control Administration to request the assistance of law enforcement.
The gentleman from the 66, Douglas Espinoza, to explain the bill.
Thank you, Mr. Speaker. House Bill 3105 would permit the Alcohol Beverage Control Administration to request the assistance of local law enforcement. Current code only allows the ABCA to request the assistance of the state police. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? The gentleman 23rd, Delegate Miller.
Gentleman would please yield. Thank you. Under the provisions of this bill, at the very beginning, under 6217A, lines 1 through 8, does this permit law enforcement officers to enter an ABCC licensed establishment once the agency has requested in writing help with law enforcement?
Could you tell me what page you're on or what section you're in?
I am at the top of page 2.
And repeat your question, please.
Well, let me put it a different way. It's my understanding that the ABCC can, in writing, ask for assistance from law enforcement in the enforcement of their provisions. That's covered in code. Am I correct in that under this?
They are, but currently council advises that it's restricted to state police. That's there on line 2, there at the top of the page.
Yes, sir, understand that. But under the provisions of this bill, ABCC can request the assistance of local law enforcement, sheriffs in the enforcement of ABCC rules and regulations. Am I reading that correctly?
Yes, they could.
Does that also mean that they can request the assistance of local law enforcement, that they can act absent and separate from direct participation with the ABCC enforcement officers? Can they act on their own once that writing has been issued to a law enforcement agency asking for assistance?
Council advised that they would need a specific request to enter these establishments unless they witness a crime being committed.
So let me ask it in a different way. Can the ABCC submit in writing a request to a local sheriff or police department for assistance in the enforcement of their rules and regulations.
The ABCA or the Alcohol Beverage Control Commissioner can request that assistance from local law enforcement.
So once, am I correct in assuming that once that request is made, that gives local law enforcement the authority to enter an ABC licensed establishment for the enforcement of ABC rules? Is that correct?
Upon request, that's correct.
But under current rules, the way it is without this, in order for local law enforcement to enter an establishment, they have to have probable cause and have a search warrant to go into that private club or facility. Is that correct?
That is correct, and that's why it would be upon request of the ABCA.
Can the ABCA issue a request, for example, on an annual basis or for any particular time frame whereby local law enforcement would have a blanket coverage to enter an ABC licensed establishment as they see fit for the enforcement of ABC rules and regulations that they currently do not have the ability to do?
I'm told that in testimony that the answer to your question would be no. This would be subject to a specific request, perhaps to assist with incidences of underage drinking, for example, but it would be based on a specific request.
Is there anything that prohibits that type of request being made for a blanket coverage for a law enforcement that is currently prohibited from entering to do that on a regular course of business?
I'm told by counsel that they have to be accompanied by ABCA on each of these, each time that they would, enter such an establishment. So the practicality of a blanket request was probably not consistent with this legislation. It would have to be because ABCA is going to be with them each time, essentially there would be a request each time for local law enforcement to assist.
If I'm reading this correctly, it doesn't say that they must accompany ABC agents. It just says that they are requesting the assistance of. Can they request the assistance in absentee of their enforcement officers to enforce provisions of rules and regs under licensure?
I think the reading of the committee substitute, I think makes it clear that this request must be in writing from the ABC commissioner, and points out that it would request the assistance of sheriffs, deputy sheriffs, municipal police officers in the coordination and enforcement. So it's, I think the clear reading of the committee substitute is that this would be in an assisting role.
I understand. Let me ask it in a different way. Could this be perceived similar to a mutual aid agreement whereby one agency assists another? similar to what's provided under Chapter 15 with mutual aid between law enforcement agencies. Whereas one can act in absentee of the other. It doesn't seem to be clearly defined or specifically outlined.
Council advises that no, that would not be a fair comparison.
But it doesn't specifically exclude that from happening the way I read this.
ABCA is not a law enforcement agency, so they would not have law enforcement powers.
Oh, I understand that, but they have administrative authority for the enforcement of theirs. I'm asking if this is similar to a mutual aid agreement, because it gets into where the sheriffs, deputy sheriffs, municipal police officers who are assisting with the civil and administrative enforcement of the code may further act.
I would, to my colleague, I would say no. I think, again, as the committee's substitute indicates, this is a request to assist with the coordination and enforcement. So wouldn't really characterize it, as mutual aid. I mean, certainly they are assisting, and they're coordinating, assisting with coordination and enforcement. Whether that would, you could construe that as similar to mutual aid. This legislation doesn't address that. Clearly, it's at the request of the ABCA.
And to further clarify, my concern is that a law enforcement agency would not be required, because it goes on line 5, further such assistance shall not be withheld, that a law enforcement entity is not bound to enter private clubs and establishments on their own and create basically policing an ABC establishment separate and on their own.
If the request is made, and please let me know if this is not responsive, if the request is made, you are correct that such assistance shall not be withheld.
So if the director asks a sheriff, he must supply someone to go with him and cannot because of manpower or otherwise turn that down? Or a police chief or other local law enforcement?
The legislation says that it shall not be withheld, but I think it also speaks to the fact that there's, it calls for coordination and enforcement. I mean, I think clearly the ABCA, would, try to, obviously reach out to local law enforcement for assistance. If for some reason there was a shortage of manpower, I would presume that the ABCA would look to other local law enforcement if state police aren't available to perhaps assist, with the enforcement. So I think we would have to expect that the ABCA and local law enforcement would work well and recognize that sometimes there are going to be shortages of manpower in particular situations.
Okay, thank you. Thank you, Mr. Speaker.
The gentleman, the 55th, Douglas Pennagle.
Thank you, Mr. Speaker. I'm going to vote no. Again, every year it seems like we keep trying to put cops in every bar in the state, and this is what we're attempting to do here by backdooring it in by giving the assignment power of the ABC to law enforcement to go into bars. Now, we've had this issue come up with Morgantown I don't know how many times to try to just say we can put cops anywhere we feel like it. They are private clubs. Private clubs. They have property rights, and they can say, we don't want law enforcement to come willy-nilly in here and harass our business. Now, we've said that over and over and over again. We allow the ABC to go in there because they sell alcohol, but we don't allow any law enforcement just for the heck of it to go in and start raiding these places and harassing our bar owners. So they have a right to say no. They have to get a search warrant, as the gentleman from Boone said, to get a search warrant to go in if they believe illegal activity is going on. But we just don't say you can go in and do whatever you want. Every year, we keep knocking this down. Now we're trying to backdoor it. I'm going to vote no.
The gentleman, the 50th, Doug Angelucci.
Thank you, Mr. Speaker. This is a good bill. This helps our college towns and universities. We have a shortage of ABC investigators throughout the state. This helps ensure that we're keeping our underage drinking in check. So I urge passage. This is a very good bill, and it's very much needed in this state.
The lady at the 49th.
Thank you, Mr. Speaker. Due to many questions still unanswered, I'd like to ask unanimous consent to postpone action 1 day.
Lady in the 49th asks unanimous consent to postpone action 1 day. Is there objection? Chair hears no objection. Action will be postponed 1 day. Next bill on third reading.
Committee substitute for House Bill 3131 relating to providing salary adjustments to employees of the Department of Health and Human Resources.
The gentleman at the 27th, Douglas Ellington, to explain the bill.
Thank you, Mr. Speaker. This bill will permit the Department of Health and Human Resources Secretary to increase salary ranges for job classifications within the DHHR. This increase will be determined by a job market rate study to determine the salary range a job classification should be. The job classification salary ranges provided by the Division of Personnel are currently so low that they are preventing DHHR from hiring the additional staff it needs. As an example, DHHR would like to raise the salary ranges for CPS workers and could use this authority to do so. The second section of the bill provides a broad grant of authority to the Secretary of DHHR to set the salaries of employees who assist in the direct or indirect provision of medical care to patients in the state hospitals. This will assist the department in hiring healthcare professionals to provide the necessary services to individuals within the state's care. Any of the salary adjustments must come from existing budgeted funds. Additionally, the bill provides DHHR with the same authority that was given to the Department of Highways last year to hire at-need positions. This provides an expedited hiring process for DHHR. DHHR is also exempted from similar DOP hiring requirements, as was the Department of Highways. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? Are there members who wish to speak to the passage of the bill? If not, those in favor will vote aye. The lady from the 50th, Douglas Longstreth.
Thank you, Mr. Speaker. Would the chairman yield for a question?
Chairman does yield.
Yes, ma'am.
Was it last year, did we not have this bill and did we not pass it to let DHHR set these salaries and decide to make salary increases? Or was that a different bill?
That was probably a different bill. We were looking at letting them make some adjustments, but you're probably thinking of something different.
That's probably all further that it went. Okay. Thank you.
The gentleman from the 50th, Douglas Caputo.
Chairman, continue to yield.
Chairman does continue to yield.
Yes, sir.
Mr. Chairman, does this affect civil service protections in any way for employees?
Council tells me it does not.
It does not.
Right.
Are there other members who wish to speak to the passage of the bill? If not, the question before the House is, shall the bill pass? Those in favor will... One final time, lady from the 51st for a question.
Well, I haven't spoken yet.
Well, chair's tried to close debate twice, but we'll let this
sorry.
one go. Lady from the 51st.
Would the gentleman continue to yield?
Yes, sir.
Does this affect their grievance rights?
Council tells me it does not.
So there's no provision that disallows grieving over these raises?
No, there is not.
Okay, thank you.
Lady number 36, Douglas E. Step Burton.
Thank you, Mr. Speaker. Will the chairman yield?
We'll
Does
do
this
so. You guys give
include-
me exercise today. Thank you.
Thank you. Does this include the deputy secretaries and the top administrative staff as well?
I don't think so. I think those are salary ranges we put in. I think that's legislative. This is
Okay.
people underneath that.
The deputies, not the secretaries?
Council tells me that those are set by the secretary already, but that's not in this bill.
Okay, thank you.
The gentleman from the 46, Douglas Martin.
Thank you, Mr. Speaker. Would the chairman continue to yield?
I'm just going to stand here.
I just wanted to make sure when we're talking about hiring folks, we're not talking about any private contractors. We're just talking about directly people that work for the hospitals.
Correct.
And I noticed that there was only Sharps Hospital and Bateman Hospital, and you guys just put any other employees who direct or in. indirect?
Well, there are actually 7 hospitals that they have, but Sharp and Bateman were the 2 that were mentioned in the bill. But they have 7 hospitals, and if you want me to elaborate, there are a number of positions that are available and contracted care, stuff like that.
Okay, so this would just make it a lot easier for them to hire there at the hospitals?
Correct.
Okay, thank you.
Ladies from the 52nd, Douglas Sipo.
Chairman Yield,
That's why I didn't sit down.
I just want to confirm one more time that this would allow that the patient or that the employees at the Hopemont Hospital could finally earn what they deserve.
Yeah, so that's the point. Let me just elaborate on this. We have 7 hospitals that the DHHR regulates, 469 vacant positions, 178 are temporary staff, 310 are contract staff, which are paid more than what they would get if they hadn't raised their salary and benefits. So they're having a hard time doing that. CPS, there's 85 vacancies out of 472 positions, and overall the department has 1,200 vacancies. So they're not hiring these people, they're not retaining them, so they need the ability to start filling these positions so they can take care of the patients.
Thank you. I just wanted to hear that one more time. Thank you.
The gentleman from the 37th, Douglas Pushkin.
Thank you, Mr. Speaker. Chairman Neal?
Yes, sir.
I've heard some questions about this, how it relates to the state hospitals. I'm sure everybody knows the problems we have there and wants to be able to, for the department to be able to raise salaries to attract people out of the private sector in those hospitals. However, does this not affect the entire department?
It does affect the department, but it's salary ranges, okay? And it has to be consistent throughout. They can't give one person a certain amount, another person another amount. It's ranges that they could hire within and adjust those ranges.
Okay, because I'm trying to find it here, but I think it says, or any other office. That's pretty wide
That are
open.
within the indirect care of those. It said direct or indirect care, so it's within their division.
Okay, so that's the entire DHHR, though?
Right. No, that's just for those hospitals, but the entire DHHR he can do different salary schedules for them too. But he has direct authority over the hospitals.
Okay. I guess I remember during the committee that when we asked about that line, any other office, that I believe it was the secretary said it was the entire department. Maybe.
I believe, the council tells me that portion was changed in the government org.
Yeah. Oh, they changed that?
Right.
So it's more narrow now? Just okay. All right, thank you.
The gentleman from the 17th, Douglas Rohrbach.
Thank you, Mr. Speaker, and I'm going to rise in support of this bill, and the chairman, I don't have a question. The reason we need this bill, there's nothing sinister going on here. This state has 7 hospitals, as we just alluded to. One of these hospitals actually lost their accreditation from CMS, and we had a number of hearings in regards to that on the LACRA over the interims the last 2 years. One of the big reasons that they lost their accreditation was their inability to hire staff. And pure and simple, a lot of it got back to pay. So if we're going to stay in the business of running these hospitals, we're going to have to compete for the staff that we need to run these hospitals appropriately. That's all this bill is about. Another complaint that we all hear from our communities, CPS workers. And again, this is going to get back to pay. If we're going to recruit the CPS workers, we've got to pay a competitive rate. That's all this bill is about. And when we had these hearings about losing accreditation on LACRA, and we went into what we were paying for the contract employees, it was frankly staggering. We can more than pay these folks, fill these positions, and save the state money by doing this. So I would urge the members to vote for this bill. This really allows us to run these hospitals and healthcare facilities appropriately. Thank you, Mr. Speaker.
The gentleman of 36, Douglas Rowe.
Thank you, Mr. Speaker. I've become confused, and I'm wondering if the chair would yield for another question.
Chairman does yield.
Yes, sir.
On questioning from the delegate from Kanawha, it was my understanding that only hospital employees were affected. But then from the questioning or the statement from the gentleman from Cabell, in fact, CPS workers would be included. What's the scope of who are the employees that would be affected by the bill?
Both are. There's 2 parts to the bill. First part is in general for employees. The second part is specifically to the hospitals. Okay, which gives them a little extra authority to not circumvent the system, but at least expedite the system better.
And it's true, isn't it, that the department is special in the sense that their salaries are so low across the board.
Across the board, yes.
Just all employees, clerical employees, they're all very, very low paid. And this would allow the secretary to start making adjustments with that.
They can adjust the ranges so that those people can be elevated into those ranges, yes.
Now, would they require a special budget appropriation, or can they do that with the vacancies that they have?
Yes, with the vacancies, they could use their position. It's not supposed to increase their budget. It's supposed to be money that's already in their annual budget.
All right. Thank you, sir. Thank you.
The lady from the 52nd, Dr. Seipold.
Thank you, Mr. Speaker. May I speak to the bill?
Lady may proceed.
I am not confused. I just would like to say I would like to ask support for this bill because the employees at the Hopemont Hospital deserve a decent wage. Thank you.
The gentleman from the 59th, Dr. Kump.
Thank you, Mr. Speaker. I call the previous question.
Chair will note there are no other members seeking recognition. Question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 87 ayes, 12 nays, 1 member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 3131.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House and the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3136, relating to the Centers for Medicare and Medicaid Services.
Lady in the 49th.
Thank you, Mr. Speaker. I ask unanimous consent to postpone action one day.
Lady in the 49th asks unanimous consent to postpone action on House Bill 3136 by 1 day. Is there objection? Chair hears no objection. Action postponed 1 day. Next bill on third reading.
House Bill 3137, relating to Personal Income Tax Fund.
Lady in the 49th.
Thank you, Mr. Speaker. I ask unanimous consent to postpone action 1 day.
Lady in the 49th asks unanimous consent to postpone action by 1 day on House Bill 3137. Is there objection? Chair hears no objection. Action is postponed 1 day. Next bill on third reading.
House Bill 3139, relating to funding of the Public Employees Health Insurance Program.
The gentleman of the 64th, Douglas Householder, to explain the bill.
Thank you, Mr. Speaker. House Bill 3139 would create a new section requiring the Secretary of Revenue to assess and collect from employers participating in PEIA a new rainy day fee for each full-time equivalent employee of the employer determined as of April 1st, 2019, at any amount determined by the Secretary of Revenue to be necessary to fund a new PEIA rainy day fund. Finally, the bill would create the new PEIA rainy day fund administered by the Secretary of Revenue, consisting of monies collected from the PEIA rainy day fee. Upon the written approval of the governor, the Secretary may transfer monies from the PEIA rainy day fund to the Public Employees Insurance Agency only to 1, reduce or prevent benefit cuts, 2, reduce premium increases, or 3, any combination thereof. The amount of monies transferred may be included in the calculation of any plan year aggregate premium cost sharing percentages between employers and employees. I urge passage.
The question before the House is, shall the bill pass? The gentleman from the 36th, Douglas Rowe.
The chairman would yield for a question, please, sir.
Yes.
Okay, now we talked earlier about the rainy day fund, and we put, the vote was $105 million, I think, into this fund. But now, does this bill provide for assessments, or is that in a different bill?
No, there is an assessment of $45 million roughly in this bill.
All right. Now, as I understand it, the rainy day fund is general revenue funds.
You're correct.
And that it will go to the agencies who have general revenue appropriations, correct?
Correct.
But for any agency that has special revenue folks, they don't receive any of this money, so they're going to have to come up with that as out of whatever budget funds or special revenues they have, correct?
You're correct.
So the effect I think heard in Finance Committee was that on higher education institutions, that there was an unfunded mandate of, and I'm trying to remember the number.
It's about $16 million.
All right, that they would have to come up with, because much of their funding is not from the general revenue budget, it's actually from special revenue like tuition and fees and federal grants and that sort of thing.
Yeah, you're correct.
So are there any other agencies than higher education that might feel the burden of this because they have to come up with the assessments?
Not that I'm aware of.
Okay, but the burden, actually, $16 million is probably more than what we've been cutting them for the last 5 years, correct?
But keep in mind, to the gentleman, we're with that PEIA supplemental that we passed. So you're taking money from fiscal year 2019 general revenue, and what you're doing with that money, you're putting it into the new rainy day fund so that it pre-funds 3 years of future cost of premium increases. So you're getting an advantage. You're pre-funding 3 years of those future costs, which is a plus.
Right. For general revenue agencies like the Department of Health and Human Services, highways, and so on.
Yes.
For those agencies, they're really pretty secure.
Yeah.
But for the higher education institutions, they've got a $16 million unfunded mandate that they've got to come up with $16 million and send back to, I guess, to the rainy day fund or to the state on assessments each year.
And don't forget, there is a hardship waiver that we have in the bill. The Secretary of Revenue could grant the hardship waiver and give them up to 6 months additional to pay.
Right, but only 6 months, and that means that within one budget year, they're going to have to come up with a substantial sum of money, and I assume it's based on the number of employees that they have who are not covered by general revenue funding.
You're correct.
So this is really. May I speak to the bill? Thank you, sir.
Gentleman, may proceed.
Yeah, let me just say this. It's good to have a rainy day fund for PEIA. But what this bill does is to create an assessment against every agency. Now, if you're an agency like DHHR or Department of Highways, hey, what's the problem? All of your employees are covered by general revenue funds. So you're going to get your assessed amount out of this rainy day fund. Hooray, that's good. But if you're a college or a university that has, almost all of them have probably only a third at most of their budgets come from general revenue from what we appropriate to them. Substantially, WVU's is much greater. Our contribution to WVU is much smaller than a third. They are going to have to come up with, for each employee under special revenue funds, an amount to pay into this rainy day fund. Now, it's an unfunded mandate to higher education of about $16 million. Our reductions for the last 5 years that have crippled the institutions, that have forced tuition to almost double in those 5 years. Yes, we've gone from being very inexpensive in tuition to we're now starting to get to the point where if we keep raising tuition, we're going to be more than the surrounding states that we compete with. This is a very, very difficult thing, and I urge that we not pass this bill because the assessments cannot be borne by higher education. $16 million unfunded mandate. It's a greater cut than what we've been doing for the last 5 years, and it's really backbreaking to higher education. And if we were to turn this down, I think it would be a substantial statement that we are concerned about higher education and that we're going to do something about fairly funding them, unlike in the last 5 years when we've been cutting them on a regular basis. Thank you, Mr. Speaker.
The gentleman, the 16th, Doug Linville.
Thank you, Mr. Speaker. The Chairman of Finance yield for a question.
Yes.
Thank you, Mr. Chairman. Discussed upstairs, and I think a little bit previously, the gentleman from the 30th had alluded to the fact that supposedly there was no new money that would be coming in here. Is federally funded positions considered, or are federally funded positions considered special revenue?
Some are, yes.
Okay.
Yeah.
And so in this instance, when we're doing this assessment, would federally funded positions get this assessment?
We're doing this assessment so we can capture that money so they can pay their fair share.
Exactly. And so the federal government would be paying their fair
Exactly.
share into PEIA.
Exactly.
Thank you. May I speak to the bill?
Gentleman, may proceed.
So right there is new money that we're pulling in from the federal government. That's the entire purpose of this assessment, is so that we pull in new money from the federal government rather than from the taxpayers of the state of West Virginia. It's coming from taxes, both obviously that the citizens of West Virginia paid up to the federal government that we would not otherwise realize. I support this bill, pass this, take more money from the feds and use it to fund our public employees' health insurance. Thank you, Mr. Speaker.
The gentleman from the 55th, Douglas Spinagle.
Chairman Neal, I believe up in finance, the reason we're doing it this way, and I call it a money laundering scheme, is in essence, the state's saving $45 million by assessing everybody, then having the money come back up to us and then send it back down. Is that correct?
That's correct.
Okay. The concern is, of that $45 million that we're saving, we're assessing the universities roughly $16 or $17 million, which are getting hit. Is it the intention of the finance chairman to, when the budget comes around, to take in consideration that amount and place that back in the budget at some place?
I can take it into consideration, but keep in mind, to the gentleman from the 55th, let's just say the assessment, there is a hit of $16 million, but without reaching out to each agency or without reaching out to each of the higher eds and saying, what are your true costs? Let's just assume in this hypothetical that it's really an $8 million cost. Keep in mind, they would have until December, at the end of December 2020, before this fee is even due. So we're talking a year from now before this. I mean, and there is a hardship waiver. Remember, they have to pay by June 30th of 2020. So if the secretary grants them a waiver of 6 months at the end of December 2020 is when this assessment would be due.
If I recall, though, the concern with the hardship waiver was that if we started granting that excessively, then the feds could not pay the assessment because they said it's a sort of a sham that we're trying to do.
Well, I can't speak to that. I don't recall that. But to answer your original question, I'm going to do what I can to make sure that if we have available dollars, then we'll see what we can do.
All right. Thank you.
Yeah.
Are there other members who wish to speak to the passage of the bill? Does the gentleman wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 93 ayes, 6 nays, 1 member absent not voting. A majority of the members present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 3139.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Lady from the 49th.
Mr. Speaker, I move that the bill take effect from passage.
Lady from the 49th moves the bill be made effective from passage. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. The gentleman from the 29th, Douglas Steele, your vote is not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 95 ayes, 4 nays, 1 member absent not voting, 2/3 of members elected having voted in the affirmative. The chair declares the bill effective from passage. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3140, relating to the Division of Natural Resources Infrastructure.
The gentleman from the 58th, Doug Coles, to explain the bill.
Thank you, Mr. Speaker. House Bill 3140 is a clarifying bill at the request of the DNR. During the 2017 legislative session, the legislature exempted certain Division of Natural Resource contracts from the review and approval of the requirements of the Purchasing Division. Under the code, for a contract to be exempt, the contract had to, 1, must provide for exploration, conservation, development, protection, enjoyment, or use of the natural resources of the state. 2, must be for repairs or related construction to protect public health and safety. And 3, must be for lands and facilities under the jurisdiction of the DNR. Interpretation issues have arisen, and the DNR is asking that we resolve the problems with a language change to clarify. Also, the original bill makes a requested change that adds state forest to the definition of recreational facilities. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, 1 member absent not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 3140.
Are there amendments to the title?
Delegate Anderson moves to amend the title.
Question before the House is the adoption of the title amendment. Those in favor will say aye. Those opposed will say no. Ayes have it. Chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. Lady from the 49th.
Mr. Speaker, I move the bill take effect from passage.
Lady from the 49th moves the bill be made effective from passage. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, 1 member absent not voting. 2/3 of members elected having voted in the affirmative. The chair declares the bill effective from passage. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 3141, requiring Capitol Building Commission authorization for certain renovations.
The gentleman from the 35th, Doug Capito, to explain the bill.
Thank you, Mr. Speaker. I'd ask unanimous consent to amend the bill on third.
The gentleman from the 35th asks unanimous consent to offer an amendment to the bill on third reading. Are there objections? Chair hears no objection. The gentleman may proceed with the amendment.
Thank you very much, Mr. Speaker. This was an originating bill that we did in the Committee on the Judiciary, and there was an amendment that was adopted in committee but was not integrated into the bill before you, so that is what we seek to change. The amendment can be found on page 1, line 13. We're striking out the 2 words, "the public," and inserting in lieu thereof the word "all." This will keep it consistent with the definition of substantial physical change. So I would recommend adoption of the amendment.
The question before the House is the adoption of the amendment as just explained by the gentleman from the 35th. Are there members who wish to speak to the amendment? If not, those in favor of the amendment will say aye. Any opposed will say nay. The ayes have it. The chair declares the amendment adopted. Are there further amendments? If not, clerk will read the bill a third time.
House Bill 3141, requiring Capitol Building Commission authorization for certain renovations.
The gentleman from the 35th to explain the bill.
Thank you very much, Mr. Speaker. This bill deals with the Capitol Building Commission, and as some of you will recall, last summer we had some discussions on what was and was not a substantial physical change to our building. There were some renovations that occurred in certain members' offices that we had long and lengthy debates over in this body that occupied much of our good weather that we spent in here last summer. What this bill seeks to do is expand the jurisdiction of the Capitol Building Commission. Currently, the Capitol Building Commission will review and approve or reject any changes, substantial physical changes to the building that we sit in right now and all of the surrounding areas that are considered the state capitol complex. What we're doing with this legislation is changing some of the wording in this part of the code to include all areas. We got kind of stuck on what was considered a public and private area, and that's kind of how we got into the mess that we were in last year. So what this bill and what this legislation does is it says that any area of the Capitol, all areas of the Capitol complex, both inside and outside the Capitol, must run through the Building Commission, and that before a contract may be let or before changes are started, if the work is not done under a contract, or before the work on a change order is begun, the commission must approve, review, approve, or reject the suggestion. Mr. Speaker, that's the bill, and I urge its passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. Of this question, there are 99 ayes, 0 nays, 1 member absent not voting. A majority of those present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
House Bill 3141.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 3143, relating to requirements for consumer loans in West Virginia.
The gentleman from the 27th, Douglas Schott, to explain the bill.
Thank you, Mr. Speaker. House Bill 3143 provides an opportunity for West Virginia and state finance lenders regulated by the West Virginia Division of Financial Institutions to provide consumer finance loans in circumstances where those in need might have to resort to unregulated payday or title lenders. Typically, these loans are unsecured, non-revolving, and short-term. The primary purpose of the bill is to adjust the limits for 3 loan brackets on consumer finance loans for the first time since this section was last amended in 2001, in other words, 18 years ago. The bill provides that in the first loan bracket, the loan finance charge may not exceed 31% per year on the unpaid balance of the principal amount on a loan of $3,500 or less, which is unsecured by real property. Currently, the cap is $2,000. This would raise the cap to $3,500. I should state that is the cap on the interest rate. The interest rate could be less, but that's the cap. The second loan bracket, the finance charge may not exceed 27% per year on the unpaid balance of the principal amount of the loan of more than $3,500 up to $15,000. Under current law, the 27% cap applies to loans greater than $2,000. So this goes from $2,000 to $3,500. The third loan bracket, the loan finance charge on any loan greater than $15,000 may not exceed 18% per year on the unpaid balance of the principal amount. Under current law, the 18% cap applies to amounts greater than 10%. This raises that to 15%. Also, the loan finance charge may include a charge of not more than a total of 2% of the amount financed for any origination fee, points, or investigation fee when a loan is non-revolving and is greater than $3,500. Under current law, the 2% limit applied to non-revolving loans greater than $2,000. So that raises that limit, that threshold to $3,500. This bill was passed by the Senate both in 2017 and 18, but failed to advance here in the House just because we ran out of time. So we're bringing this up again, and Mr. Speaker, that's the summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? Or the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 76 ayes, 20. Clerk will close the machine. On this question, there are 75 ayes, 24 nays, one member absent, not voting. A majority of those present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 3143.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3145 relating to student financial aid resources.
The gentleman from the 48th, Douglas Hamrick, to explain the bill.
Thank you, Mr. Speaker. The Underwood Smith Teacher Scholarship Program currently provides scholarships of $5,000 or less to undergraduate and graduate students who meet certain academic qualifications and who commit to teaching in the public school system. The bill changes the program name to the Underwood Smith Teaching Scholars Program and modifies the program as follows. It shifts the focus of the students pursuing teaching careers in math, science, special education, or music education in a geographic area of special need. It changes the eligibility requirements to requiring a cumulative GPA of 3.25 on a 4.0 scale. Scholarship recipients are required to teach in the state for 5 consecutive years following graduation. The average cost shall be calculated according to the annual undergraduate tuition and mandatory fee rates charged by the state residents or to state resident students. Mr. Speaker, I urge passage.
The question before the House is, shall the bill pass? Or the members who wish to speak to the passage of the bill? If not, those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. The gentleman from the 24th, Douglas Tomlin, your vote's not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result of this question. There are 98 ayes, 1 nay, 1 member absent, not voting. A majority of members present having voted in the affirmative. The chair declares the bill passed. The clerk will please report the title.
House Bill 3145.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 3146 relating to retail licensees.
The lady from the 49th.
Thank you, Mr. Speaker. I ask unanimous consent to postpone action 1 day.
Lady from the 49th asks unanimous consent that action on House Bill 3146 be postponed 1 day. Are there objections? Chair hears no objections. Action is postponed 1 day. Are there further bills on third reading? If not, lady from the 49th.
Mr. Speaker, subject to announcement, your House will stand in recess until 3 p.m.
Lady from the 49th moves that subject to announcements, the House stand in recess until 3 p.m. Are there announcements? The gentleman from the 28th, Douglas Pack.
Thank you, Mr. Speaker. Republican members of the House will caucus here in the chamber at 2:30.
Lady from the 49th, Douglas Summers.
Thank you, Mr. Speaker. Your Committee on Rules will meet at 1:15 behind the chamber.
The gentleman from the 10th, Doug Kelly.
Thank you, Mr. Speaker. We announced yesterday that the Energy Committee would meet today at 2 o'clock. That meeting's being postponed until Thursday, and further announcements will be made about that meeting at the time. Thank you.
The lady from the 3rd, Doug Storch.
Thank you, Mr. Speaker. Your Committee on Political Subdivisions will meet at 1 o'clock today in House Education.
The gentleman from the 13th, Doug Cadle.
Thank you, Mr. Speaker. Your Committee on Agriculture and Natural Resources will meet this evening at 7 o'clock, Government Organization Room. Agenda is posted.
Lady from the 38th, Doug Graves.
Thank you, Mr. Speaker. I have 2 announcements. The first is that your Committee on Pensions and Retirement will meet at 4 p.m. today in the House Finance Committee room. The agenda has been posted. I like this next announcement a lot better. So one of our head doorkeepers, Robert Stewart, is once again, new grandfather today. Early this morning, his 27th grandchild was born. His name is Steele Stewart.
The gentleman 21st, Doug Dean.
Thank you, Mr. Speaker. Your Committee on Education will meet tomorrow at 3 p.m. in the House Education Committee room. The agenda will be posted.
Gentleman the 41st, Doug Hill.
Thank you, Mr. Speaker. Your Committee on Health and Human Resources won't meet at 2 o'clock today, but it will be after this evening's floor session. And Republicans will caucus 30 minutes prior to the meeting.
The gentleman from the 50th, Doug Caputo.
Thank you, Mr. Speaker. Democratic members of the House will caucus at 2:30 p.m. in the House Government Organization Room, 2:30 p.m.
The gentleman from the 53rd, Doug Jennings.
Thank you, Mr. Speaker. Your Committee on Fire and EMS will meet today at 5 in GovOrg. Thank you.
The gentleman from the 35th, Doug Capito.
Thank you, Mr. Speaker. The Committee on the Judiciary will meet tomorrow morning at 9 a.m. in the committee room, and the agenda will be posted.
Are there further announcements? If not, the question before the House is the motion by the lady from the 49th that the House stand in recess until 3 o'clock. Those in favor will say aye. Those opposed will say no. Ayes have it. The motion is adopted. The House is in recess until 3 o'clock this afternoon.